counter affidavit that I have joined the investigation. Only plea is that, Malas, that I have not given a will, Malas, which has not been given by the predecessor to me, Malas. I have given the photocopy of that will, Malas. There is no dispute that civil suit have been filed first. When they are not able to get the injunction, then they file the FIR, Malas, in the matter.
Lords, so far the present case is concerned, it is a case of.
There are two ALGs appearing in the matter.
Perhaps my friend is not. But then in that case.
Being a criminal matter is having moral supervision over it.
Plus, I'm appearing for the complainant, Milords. Milords, my submission is he impersonated as government official from the DCP Dwarka office, Milords. Milords, there is CCTV footage of the same, Milords. Milords, may just see the page number 37.
Let the SG please address. You are the complainant. You can only support the prosecution.
Yes, Milords.
Lord, apart from the fact that he did not cooperate with the prosecution, investigation, he did not produce the documents when he was asked to come, then he escaped. Therefore, the proceeding under section 82 has been taken, which is pending, my lord, because there was an interim order by this court. And then, my lord, during the pendency of the investigation, he has again sold the land on the basis of forged documents, which he created originally to claim his title over the land, and he has sold it, my lord, to his son, my lord. So, creating, my lord, one after another documents, my lord, for the purpose
have you stated so in your counter?
Yes, that has been stated in my counter affidavit. If your lordship will see the counter affidavit, we have filed the counter. Lordship will see paragraph 12 below the relevant portion wherein this has been stated specifically. During investigation, paragraph 12 below, page 7, revealed that the wife of accused Seema Yadav, in connivance of the present applicant, have again transferred the property in question to her son, namely Prashant Yadav, on 24/1/2023, and further Prashant Yadav sold 50 yards out of property in question to one Surinder Singh. So, Milord, right from the inception, Milord, they have been creating false papers. Therefore, when the police asked for producing the original, not only that, Milord, when they claimed that this property has come to them by another person, one Ramchandar. Now, when the Ramchandar was traced, my lord, he could not found. Ram Prakash, my lord, he became non-existent. So, right from the beginning, everything is. So, right from the beginning, my lords, everything is forged and fabricated. Therefore, my lord, this is not a case of a false implication of a person for consideration of.
Whether the joined the investigation subsequent to the orders dated 9th of September 24.
I went there.
We are asking him.
Please.
Now, my lord, in response to that, he was present, but he did not produce any document. The document which was asked, my lord, only one document, title document, he did not produce it. And therefore, the 3 times court
May also see the page 18.
rejected the anticipatory bail thrice. His anticipatory bail, he attempted thrice, my lord. And all the time his anticipatory bail has been rejected, my lord, because he did not cooperate with the investigation. And even with the court, my lord, he did not produce the document. Please, sorry.
According to him, he doesn't. You want an original, I think.
Please, Milords, I already got the bill, Milords.
Now, your lordship will see, there were 3 parties, my lord. Now, if your lordship will see.
So, if you want, you can start dictating the order if you are so anxious. Every now and then you are interrupting.
Your lordship will see the counter affidavit, my lords. 3 parties were called, my lord. There was a claim by this petitioner, my lord, about over the piece of land, my lord. Now, my lord, first party is the complainant Bimla Bhardwaj. Then second party is Seema Yadav. And third party is Dharamveer. Dharamveer withdrew his claim. Then this Seema Yadav, when the police asked, all right, you produce the document, because the complainant produced the documents.
So basically, it's a dispute amongst the various persons with regard to apportionment of land.
Case wherein it is evident that he has produced false documents to create a title. That is the case, my lord. Otherwise,
The application is vehemently opposed by the, who is the senior amongst you?
I think my learned friend is here.
Yes. Amongst, vehemently opposed by Shri Thackeray.
In this particular I am witness.
Okay. By Shri Sanjay the learned ASG and Shri Thackeray the learned ASG. Very good. It is submitted and Miss so and so for the complaint. It is submitted that the present applicant is not cooperating with the investigation in as much as he has not produced the documents from which he has derived title. Very good. To a specific query as to whether the petitioner has cooperated with the investigation in pursuance to the orders passed by this court dated 9th of January 2024. The learned ASG fairly states that though the petitioner has attended the IO, he has not produced the documents necessary for investigation. Paragraph. It is therefore submitted that since the petitioner is not cooperating with the investigation, the application deserves to be rejected. Paragraph. The cooperation with the investigation does not mean that the accused has to admit his guilt. Full stop. You want us to observe that prima facie we are of the view that this is a civil dispute.
No, my lordship. Your lordship will see one aspect
Good,
only,
sir.
that the court will, that.
The applicant has already joined the investigation. First of all, in the event, the state finds that the applicant is misusing his liberty, they can always apply for cancellation of bail. We are therefore inclined to allow the application. The order dated so and so stands confirmed. The complainant appears to be a very powerful person. He had to get double engine. Because in Maharashtra and Jharkhand, they are saying that they require double engine if they want the state to be able to develop.
At times, Lord, it happens by mistake also.
No, it's all right. Yeah. In a lighter vein.
It's a complaint case, your lordship at granted petition. It's a complaint case, my your lordship at granted protection. I appeared, I have submitted my bail bonds also.
Who is appearing for the respondent?
Respondent number two, my lord.
Two. Status, man.
My lord, in this case, after the complaint was filed, my lord.
So the police report ignorates him.
Show that the occurrence has taken place, but at the same time, my lord, on the same date of occurrence, police went, they apprehended the two accused persons, and thereafter, my lord, bonds were executed. And the car which was used in the occurrence has been seized by the police. Now to say that the occurrence did not take place, my lord, may not be correct. Of course, my lord, and thereafter, my lord, the conduct of the accused, my lord, summons were issued, bailable warrants were issued, non-bailable warrants also, they were absconding. Thereafter, my lord, 82, 83 proceedings have been initiated against them. When your lordships protected them, my lord, by an interim order and directed them to execute bonds, bonds have not yet been executed. My lord, they are not appearing in the court.
Who is appearing for the state?
He is saying that because the complaint is an advocate,
Are you not attending the trial court?
The order sheet there in Hindi, my lord, I will translate. He has appeared, they have submitted bail bonds. So first, my lord. Second, my lord, the vehicle is not seized in the police station. That's an incorrect statement in the counter affidavit. The vehicle was never entered in the GD because the incident was false. They say that the dacoity incident was occurred and the vehicle was never seized. Second, my lord, they have submitted bail bonds. I have the order sheet. They are appearing before the trial court. Two sets. And my lord, this is also. They appeared earlier also, then they have separate. They are appearing and we. This is my lord, one copy of bail bond, my lord, it's in Hindi. This is.
Yes, that's the incorrect statement that you are making.
These are the applications.
My information.
No, the state, I'm talking about the state. That's not correct. The application is vehemently opposed by Sri Singh, the learned senior counsel for the complaint.
The decision of your lordship, recent decision, my lord, in the case of Srikanth Upadhyay, that when 82 proceedings are pending and they have non-bailable warrants are issued against them, then your lordships may not grant anticipatory bail. Maybe
Yes.
just,
I thought recent judgment said it is not a bar.
my lord.
It is not a bar. The last
No,
one.
it indicates, my lord, if I may just.
All depends on the fact of it. If you have the police, yes, the police report itself exonerates them.
One of the police report has got me, this is the complaint.
Yeah, the application is vehemently opposed by the learned counsel for the state as well as the learned counsel for the senior counsel for the complaint. Taking into consideration the facts and circumstances, we are inclined to allow the application. The order dated so and so is made absolute.
Your record, Mr. Rudrash, also very impressive.
My lord.
Your record, your client's record.
My lord, I
How
don't
many
know, the
FIR?
state has relied more on my client's record than you, but they are.
How many FIRs against you?
Malab, there are 7 cases. Malab, of which 4 I have been, final report has been
So
submitted.
only 7.
Malab, 4 I have been acquitted in one, 4 is all over, Malab. There was no case for I was discharged. And now 2 trials are pending, out of which.
He has already appeared. You made a wrong statement that he did not appear. You made a wrong statement that he has not executed the ball. He has already appeared. Pursuant to the orders passed by this court.
Not that, was, frankly, Malab, I can't make.
But we have seen the order sheet itself. We understand Hindi. You may not understand.
But this is actually, Malab, as I understand, this is an
Yes,
application.
thank you. Next matter.
Services complaint on the state Milord's last date also they didn't appear. This for regular bail.
Last.
Uttarakhand has a standing counsel.
So pass it over. Milord.
Pass it over.
Item 5, Lord, the petitioner has joined the investigation, Lord. They have filed a reply as well.
Pursuant to the lordship's order, you joined the investigation.
The application is vehemently opposed by the learned counsel of the state. However, it is not disputed that in pursuant to the orders passed by this court dated 19th of September 2024, the petitioner has joined the investigation. That we have the matter we are inclined to allow the application. The order dated so and so is made absolute.
Sir, handed over the order passed by your losses, which covers my matters, if I can give the chart. At least that can be disposed of. So I have prepared a chart. These are the.
Let all the matters be heard together.
Oh, please. Sorry.
When do you want it?
Password.
Since I have here for the respondent. Respondent number 6 and 7. But there's one fact which I wish to bring to your lordship's notice. Lord, the learned single judge had remanded the matter back to the land acquisition officer. The division bench Lord refused to interfere. Land acquisition officer has now passed the award subsequently. It's passed in fact Lord long back. And that has not been challenged.
No, which date was taken?
No, Lord.
Section 4 date.
Issue
4 or section.
Issue regarding date is left open by both the courts.
So what head did he take?
They said insofar as.
No, what did the LA1 on remand to?
No, Levo Lord has no other option but to take the date of the notification in accordance with the act. It's only the constitutional courts which can change it thereafter. So the learned single judge rightly holds that the award has been passed, Lord, and he has found about 5 to 6 flaws. A, it is passed on external dictates. there was no direction of the state government, Advocate General's opinion, etc. Plus, we were not heard. That is what is been recorded in the judgment of the learned single judge. There is no dispute about it. Therefore, he remands it. And while not making a reference, he says it is for the constitutional court and the division bench observe that things will come after the NOS pass the award. Please see those blood observations of the witness. It may be blood that in a justifiable case.
He is for the petitioner.
I'll just, yes, I have for the. Yes, can I, this not issue of witness and find to the issue with before my last.
One more copy.
Lords, the issue my learned friend, my learned senior rightly put, Lords. Today, what has been against me is the date has been pegged as 2003, Lords. That's the date of the preliminary notification. What am I aggrieved of? The award is passed in 2019 with the rate as available in 2011, Lords. Why? Because the Advocate General gave an opinion that there's enormous delay. It will be injustice for these landowners. Please give them as per the rate available in 2019. In fact, the Advocate General opined. But the SLAO says I will give on 2011. So I also challenge that award, Millers. My prayer in the writ petition before the High Court, which decided common base writ petition, he also challenged, I also challenged. The single judge simply says, Millard, that the SLAO does not have power to do it. Also says that the opinion went beyond the scope in which it was asked for, the reference. And so on that ground said that no, the SLO is directed to pass an award as per the 2003 rate. Right, that is the situation.
Understood. Just Mr. Nakarni, this is different land from Nagabhushana land, no? There is a Nagabhushana's case referred to in the
It's the same project,
but different land, no?
different land. This is in Gotagari village, Millard, South Taluk, very much in Bangalore, in the Banarghata road, in the old
Because
Banarghata.
I may have appeared in Nagabhushana on validity.
Actually, we have no objection. Nobody will have, because
This is only on compensation.
this is only Millard date of compensation, not even compensation.
I just, while reading it, crossed my mind.
That's right.
Because there's enormous delay in the award, Millard. That was a short point, Millard. We just see the quickly have the
Date
list
of
of
compensation after SLO award.
Cannot be. With great respect.
There were 3 writ petitions.
Not in none of the writ petition, this prayer was there by then. Page 176, this was never there.
I'll show, Millard.
They challenged 2019 date, but never asked for 2003 date.
Of course, Millard. I asked for 2019. I asked for 2019. I'll show the
So
prayer.
let it challenge it and let it be done. Procedural.
Plus, permit me to place my case, Millard. Permit me to place
We'll have
my
to change the procedure now. We'll have to start hearing the respondents first and then the petitioners to respond to the.
So this was only a preliminary thing to bring the council.
He's not even being permitted to open his case. Yes.
Millard, just quickly, Millard. 3/10/94, Millard. It's very important this date because the lands in question, Millard, were converted from agriculture to agricultural and residential purpose, Millard, and from by the vendors of the 35 writ petitioners, Millard. In 94 itself, 95, the chairman of the Panchayat approved the layout plan. In 95 to 97, on various days during the period, petitioners were purchased. These lands were purchased. Millard, I'll just add one sentence here, Millard. I had purchased the land at 120 rupees per square feet. On paper, I can produce that, Millard. In 1907, a framework agreement was executed between the government of Karnataka and Nandi, Millard, in which the infrastructure corridor project, which is famously known as the Nandi corridor, Millard. On 98, responded. On 14/10/98, applied to the respondent to make available lands for the project. NICE and KIDB entered into an agreement to execute the mandate of the land acquisition as envisaged under the framework agreement. Then, Millard, 29/1/2003, Millard, in respect of the lands of the petitioners here, Millard, the preliminary notification is passed under the KIADB Act on Section 3(1) of the Act, Millard. Notices were issued on 29/2. Petitioner also submitted their objections. After considering the objection, preliminary notification, final notification was issued on 5/7/2003. Possession taken, Millard, in 2005. Between November and December, Millard, we are all dispossessed of our lands in 2005, Millard. Plus, in 2011, a writ petition which was filed by me in 2009, seeking to quash this project and also to give me an alternate, in the alternative, where I was seeking allotment of an alternate sites, was dismissed, Millard. Now I was given liberty to place my grievance before KIDB.
In terms of that, I made a representation, my lord, which I paid 97 on 2016. I filed another writ petition for a mandamus to consider my representation, which was pending, my lord, for long. In the meanwhile, I also filed a contempt for lords. During the pendency of the contempt, on 22/4/2019, the SLO passed the award for payment of compensation in respect of land belonging to the petitioner. The market value of the land was determined based on a guideline value as prevalent in the year 2011 on the basis of an opinion given by the Advocate General, considering the delay in passing such an award. Lords, important lords, was at that point of time granted at rupees 1 crore per acre. At 141 in respect of my lands, an amount of 32.69 crores was quantified, my lords, by taking the market value as in 2011. Which there also, my lord, there's a problem because they consider it as an agricultural land, whereas it's a residential land. But that apart, my lords, I became aware of the passing of the award in my contempt proceedings when the KIDB filed its affidavit. Nice, my lords, which my learned senior represents today, they challenged this award on the ground that the SLO could not have passed the award by shifting the date, well, I will say in short, my lords, by shifting the date and considering the market value as on 2011, and he had no jurisdiction to do so. The awards were stayed, contempt proceedings in that so and so were withdrawn, my lords. I, my lords, in this writ petition filed by NICE, I first implemented myself. Then I was advised, my lords, I filed a substantive writ petition where my prayer is, my lords, to pass an award by determining the compensation in terms as per a date close to the date of the award. In fact, 2019 was my specific prayer, my lords. I will show that prayer at page 176, my lords. They filed their objections. Now the learned single judge, my lords, considers all of this together, all the writ petitions together. And on 18/4/2022, lords, he allows the writ petition filed by NICE and holds that SLO clearly fell in error in shifting the date in an impugned award, which is not only contrary to law, but also the aforesaid facts and circumstances of the case, and consequently, the impugned award deserved to be quashed on this ground alone. He says these circumstances I will not, but interestingly, the SLO says a constitutional court, a high court, Supreme Court could have shifted the date, which in fact in my writ petition was the prayer. I also show the written submission clause. Agreed by this, I go to the division bench. The division bench simply says it's premature, wait for the SLA award. These syndicals are already directed.
I would have time limit.
Plus, I have three very broad submissions. There's a following page, Milords, from 5 to 8. In 3 pages, I have encapsulated my broad 4 points for submission before my lords. One, my lord, the writ court failed to exercise jurisdiction under 226 and give me an award. This will have for a moment 176 because my learned friend seems to be in the impression I never prayed something, my lords. Just please, lords, just have 176 for a moment. 176, 276. 176.
176.
170. Issue a writ of certiorari, rather writ quash the setting aside the impugned award passed by so and so. Consequent to prayer A, issue a writ of mandamus or writ in the nature to direct the respondent to issue notice to the petition for determining compensation past the award as per market value of land closest to the date of passing the award. Plus, I am not submitting for a moment that SLO should have himself shifted the date. SLO may not have jurisdiction, my lord. I will not propound something contrary to what the law is under the Land Acquisition Act. So the SLO did not have the power. That's why I go to the High Court and seek that prayer, my lord. And very specifically, now, my lord, we'll just have for a moment page 181, my lord. 187, I'm very sorry. 187, very specifically prayed and argued at 194 of shifting of dates. 194 minutes. (194) on shifting of dates. Two important dates: 2003, 2005 possession taken, no award. The award comes to me in 2019. I specifically rely on the 1994 judgment, my lords, by Justice Verma's bench, my lord, Justice Verma, Barucha, and Justice NP Singh, my lords. That famous quotation in para 24 of Ramchand, my lords, which is I have quoted in my written submission, my lords. Now, this is what three-judge bench, my lord, of this court says, my lords. It's very important for my case because this is what I was seeking before the single judge. The petitioners, because of delay and inaction on the part of the respondents, are in a great predicament. Any amount, lots at page 7 of my written submission.
I got it.
Yeah, please. Any amount determined as a market value of their lands acquired with reference to dates of issuance of notification under subsection 1(4) of the Act at the rate prevalent 15 to 21 years prior to the date of making the award cannot be held to be compliance of the mandate regarding payment of market value of the land so acquired under the Constitution and the Act. This court faced with such a situation where proceedings have remained pending for years after issuance of declarations under Section 6 in order to protect petitioners concerned from irreparable injury and getting compensation for their lands acquired with reference to the date of notification under subsection 1(4) which may be more than a decade before the passing of the date of the making of the award, has advanced the date of notification under subsection 4 of the Act so that the market value of the land so acquired is paid at just in a reasonable date. There's a notional pegging of the date, my lords. It is still as per the LA Act, which says you determine the market value as on the date of the preliminary notification. But in exercise of jurisdiction under 226, my lord, the court only does this, or 32 or 136, my lords. The court only notionally shifts the date to a date close to the date of the award or the date of the award. For that, my lord, the enormous delay, which I will not get what exactly, my lords. This is the first submission, my lord. The single judge now, my lords, how does it hold against me, my lords? My lords, will have page 276, my lords. What weighed in the mind of a single judge, though actually on law holds in my favor.
Page
276. Para 17.8, my lords. This is a single judge, my lords. The perusal of the impugned awards will indicate that the opinion of the learned Advocate General as well as the judgment of the apex court referred to in the awards were the only two factors that were taken into account for the purpose of passing the awards by the SLAOs. As stated supra, insofar as the opinion of the learned Advocate General is concerned, the same with regard to shifting of the date to reckon the market value of the land from the date of the preliminary notification to a later date is concerned, the said opinion was beyond the scope and ambit of the query put forth to him. And consequently, the said opinion could not have been made the basis for the SLO to pass the award. Though it is sought to be contended by the respondent that the opinion of the Advocate General was not taken into account to pass the impugned award, the said contention is clearly and factually incorrect in view of the opposite facts. In the particular, the correspondence referred to is supra between the SLOs, KIDB and state government, where the SLOs have been directed to pass awards in consonance with and in terms of the said opinion. Under these circumstances, said contention of the respondent, the opinion of the advocate does not have any bearing on impact, cannot be accepted. The second factor, the circumstances, factor and circumstance that has been taken into account by the SLOs to shift the date to reckon the market value of the land from the date of the preliminary notification to a later subsequent date is by placing reliance upon the following decision of the apex court. In this context, it is relevant to state that, as can be seen from the aforesaid decision as well as the various decisions of apex court, which this court referred to, the market value of the acquired land has to be taken as on the date of the preliminary notification, as is held in exceptional circumstance, where either the apex court or the high court come to the conclusion that acquisition proceedings themselves were liable to be quashed on account of certain illegalities, infirmities in the acquisition process or procedure. It was permissible only for the apex court in exercise of its powers under 32, 142 or the High Court under 226 to shift the date. In my respectful submission on the law minutes, the single judge holds actually in my favor. Though it says that only when the acquisition is to be...
It was considering as to whether the LO could have done it.
I agree.
He told that the LO could not have done it.
I bow down. That is why I am in a writ petition substantive before the High Court, my lord, to say that 2003, 2011 is irrelevant to me. I wanted at 2019 date because that is the date of the award. That's my prayer before the writ petition. And the High Court, the High Court itself says, yes, we can do it in exceptional circumstances. I have pleaded the exceptional circumstances, simple, my lords. In 2003, you pass a notification, take my land. In 2005, you take possession and don't pay me a penny. Today, I have not got 1 rupee out of it. That is an exceptional circumstance. It does not have to be that only when the land acquisition is to be quashed. My lord, we'll just see. Following Ramchand, my lords, in Ambani's case, my lord, what had happened is, in 63, some notification happened. In 83, my lords, till 83, there was no award passed. What the authorities did to help the landowners, they passed a fresh section 4 notification to shift the date. So it would be by any mode, my lord. Here the SLO himself has excised jurisdiction. The facts are actually the same. The same KIDB could have passed a fresh notification as on section 4 on 2011, then the SLO would have been justified in giving it. The facts are actually the same. The basic fact is similarity here, sir. The enormous delay in giving a market value, which is not the actual market value given to me. This is expropriation, this is confiscation of property.
From
In 2005.
the award is passed in?
2019.
Who is appearing for the hearing?
Now, my lords, sorry, my lord.
Want to say something?
No, my lord, I just wanted to finish on another aspect which I have and covered in my written submission. Now, my lord, the SLO says that he could not have done it. I go and writ appeal. In writ appeal, how I'm non-suited, my lord. He said it's premature. Wait for the SLO. SLO has been directed to give us for 2003. He cannot do anything. And that's a foregone conclusion which he has done today, which my learned seniors pointed out in 2024. He passed those awards. But they are all wristband and they are consequential orders. And if I am succeeding in the writ petition, my lord, those awards go automatically, not binding on me. That also submission I made. Now, my lords, another point which I have not taken specifically in the High Court, my lords, I have not taken, but I relied on a judgment of the Bombay High Court in Hardas. There was an acquisition, my lords, which took place under the MRTP Act, the Maharashtra Regional Town Planning Act, a local act, just like how it has happened here. 126(3) of that act, my lords. And there what had happened, after 22 years, an award was passed, my lords, as per the old rate. The High Court, my lords, Warangabad bench dismissed that, rejected those awards and told, please give it as per the 2013 Act. I specifically have relied on that judgment. It has been quoted in the impugned judgment as well, my lords. That to say that I must now be given, one is shifting of date, first point, my lords. I say, my lord, without prejudice, that first point, a pure question of law, my lords, that even if I am given today compensation, it has to be under the provisions of the 2013 Act. It cannot by any measure, my lords, be under an old repeal act. For the simple reason, my lords, KIDB Act says under section 30 that the compensation has to be paid in terms or in of the Land Acquisition Act. For inquiry, passing award, payment of compensation, the Land Acquisition Act 1894 has been referred in the legislation. It's not an incorporation by, it's not an incorporation, my lords, it's not a legislation by incorporation, it is a legislation by reference. So what happens, my lords? Every amendment which takes place in the Land Acquisition Act will equally, the benefit will accrue to all acquisitions under the KIDB. This has been the position. They can't go behind it for a simple reason, my lords. In 1984, the Land Acquisition Act was amended.
No, but that has been settled, I think. That time limit, does it apply to KIDB acquisition? That is the whole point here.
2017 judgment.
I know, I'm sorry, but I'll deal with that. I'll deal with Justice Decree's judgment.
If you had gone under the Land Acquisition Act, there was an obligation under 1984 amendment to pass the award within 1 year.
Yes.
Now, because you are under this act, you peg it at the section 4 or equivalent provision and then leave them to the lurch.
No, thereafter they have to come to the High Court and the Constitutional Court can do it.
So the case law pre-Padma Sundar Rao, Ramchand,
Yes.
where the amendment was not there, the pre-1984 case law where there was delay, directly applies here.
No, I'm not on that, but it can be done only by the Constitutional Court, not by the Land Acquisition Officer. Because when the Constitutional Court does it, I will be heard on that point. Equities will be balanced. For example, I can show in this very matter, not how things are in my favor. We filed a writ petition saying please declare award. We filed 3 writ petitions. All that has to be gone into. Learned Single Judge rightly says that this time you have not been heard. Not please see page 282.
May I only complete, my lords? I'm very sorry, my lord. I'm sorry, my lord. I'm interrupting, my lord, senior, my lord. But I'm only finishing my point, my lord, for the simple, as a slightly subtle different point, my lords. My lords, I'm trying to make a case here, my lords, that irrespective of the shifting of the date, I have an independent case, my lords. If the award is passed today, the KIDB, under the KIDB Act, my lords, any amendment to the Land Acquisition Act will apply to it. On a basis, my lords, judgment I have placed, my lords, can I just give you a comparison of judgment and refer? Because this is, I agree, my lords. Pure question, I am not, I started with that. I am only saying it's a pure question of law. We permitted to lords raise here. What my learned friend is simply saying is this is done by a constitutional court. Go back, re-argue, come back here. From 2005 to 2019, I have waited for an award. Now I must go back to a constitutional court and argue. I am before a constitutional court, my lords. So I am only appealing to my lord's conscience under 142 to only say this, my lords, that if under that provision, my lords, on the KIDB Act, the Land Acquisition Act is a legislation by reference, then it doesn't become stillborn on that date as and when adopted in 1966 under the KIDB Act. But any subsequent amendment to the Land Acquisition Act, benefits will accrue to every landowner as and when the award is passed. In 2024, if they pass an award, they can't rely upon the Land Acquisition Act because the KIDB Act says with amendment. And on construction of a statute, Section 8 of the General Clauses Act will directly apply. I'll just quickly read, my lord, Section 8 of. The lordship must have read it a number of times, my lords, and I have also interpreted, but I'm just for my sake, my lords. I'm on a different point. I'm not on the Anusuya bypass. I'm not relying upon Section 24 of the 2013 Act to press my case. I'm relying on two different principles. One is the principle of legislation by reference, my lords, and one direct principle of interpretation under Section 8. The General Clauses Act, my lords, construction of references to repealed enactments, where this act or any central act made after, I'm sorry, my lords, Section 8(1) I'm reading, my lords. Regulation made after the commencement of this act repeals and reenacts with or without modification any provision of a former enactment, that is the LA Act. Then references in any other enactment, that is the KIDB Act, or in any instrument to the provision so repealed shall, unless a different intention appears, be construed as references to the provisions of the reenacted.
Except that we have to see the Section 8 of the Karnataka General Clause.
Section 8, yeah, I lost.
Because you are considering the KADB.
No, Lord, this, I'll tell you why, my lords, I picked this, I am only
placing same, it is the same.
Yes, my lords, I am placing this argument, my lords, I am taking support from a judgment of the Karnataka High Court itself in Shinappa's case, where the court relied on these two principles. I am pressing that as my own argument today by relying on what the single judge has held in my favor, my lords, and says that whenever the award is passed after 2014, you will have to apply the 2013 Act. The single judge has a very detailed judgment, held that, my lords. I'm just giving a compilation of judgments, my lords, for my sake. I've quoted all Ramchand and everything there, compiled here. Shinappa is mentioned, my lords, but why I'm placing that not as an authority before my lords today is because in Shinappa, the single judge applied the same reasoning which I am arguing today, my lord. The same reasoning which I am arguing today, my lord. Shinappa's single judge judgment goes in DP appeal, it's pending hearing. Shinappa's judgment then, after which, my lord, the KIDB passes a resolution in its board and says that whenever we pass an award in respect of any acquisition after 14, they have agreed that 2013 Act will apply. What remains, my lords? This will be arbitrary and unjust on me if they put me back to an old act, my lords.
You're done.
Yes, my lords. Then, my lords, on my written submission, I'm very sorry, my lords. I'll just come back to this one last part of it, my lords. I'm just reading that 8 part, my lords. Page 8, my lords, the last portion of it, which I have said, my lord, which my learned senior says that pursuant during the pendency of all of these matters on my DB appeal and this SLP here, awards came to be passed, my lords. By determining the market value of the land as on 2003, because that was directed by the High Court learned single judge, my lords, at the rate of rupees 4.97 lakhs per acre, my lords, by considering it as an agricultural land one. We'll see, my lords, today I have been, what in 2011 award which I had challenged, as per 2011 rate was 32 crores. What I get today is 2 crores. plus not the entire land, for the 11 acres of land. I'm getting 2 crores today as per the fresh award of 2024. As per the previous award of 19, I had got 32 crores as per the quantified minutes. What is the rates that they have applied? I have purchased this property in 1994-95 at 120 rupees per square feet. What they are giving me as per their rate is rupees 11 per square feet. I am saying only the gross injustice now is going to be meted out to me, my lords, if this award stands against me. And my lords, I have produced, my lords, I have looked up the website. The guideline value says, my lords, today it is 11,000 rupees per square feet. They are giving me at 11 rupees per square feet. I purchased it in 1994, my lords, at 120 rupees per square feet. The value today is 11,000 rupees per square feet. All that I am saying today, my lords, in view of that, this direction which I am praying, my lords, because your lordships are exercising a jurisdiction under 136, 142, will not be bound by the procedure which my learned friend just indicated, that you have to go back to a constitutional court, you have to be heard, and then you have to be decided on the issue. You have to challenge the SLA award, my lords. The single judge, I missed the bus before the single judge, where I have raised the very same contention which I am raising before, apart from the simple question of law which I raised on 2013 Act, my lords. I am just praying for these broad directions, my lords, that a fresh award be passed in terms of the market value as on the date of the award. Because I will request the date of the award of 2024, but even if my lords give me at 19, because the award was passed in 19, I'll be satisfied with that, my lords. I am praying for the date of the award because the fresh award has to be passed as per 24. Gross injustice will be done to me, my lords. These are people who purchase their property at age of 40, 45, thinking that they will settle and retire in their houses in 60, my lords, at age of 60. They are almost 75, 80 years old waiting for money, my lords, for this. They put their investment in the prime time of a life to live their retired life there, my lords. That's why I'm just making these submissions, my lords. That's why I'm appealing to my lords' conscience on 142, my lords. The compensation to be determined as per the provision of 2013 Act, my lords, I'm praying. And I'll be given an opportunity of hearing before the petitioner, because, lords, the SLO seems to be still holding the land to be agricultural land, whereas it's all residential lands, my lords. And the petitioner is entitled to all statutory remedy for enhancement of the reference procedure, my lords, under section 18 and the same provision, parametric provision 13, lords. I'm very grateful, lords. Very grateful.
Please, your lords. Lord, the issue here before the learned single judge was about the validity of the award that has been passed. Lord, there is no doubt that earlier notification was of so and so date, then the awards came to be passed later, etc. But so many histories, I'm not going into that in detail, but it will be required to be gone into. One, Lord, I challenged the award specifically on few grounds. One of the ground was that this award has been passed, A, without hearing me. I'm entitled to be heard statutorily. It's my right to be heard by the land acquisition officer. It's an admitted position, Lord, that I was not heard by the land acquisition officer. The second ground I said was that this is based on the external dictates by a letter of the state which said follow the opinion of the Advocate General and pass the award. And the learned single judge, Lord, finds fault with the award on all these three grounds. It says we have used the opinion of the Advocate General, it was external dictate, and therefore this cannot be sustained. The learned single judge gives a specific finding. Lord, please have a look at page 282, paragraph 17.7. Page 282, Lord, at the bottom. Please see page 282 bottom. Bottom. Paragraph 17.17. Several findings are there, but I am only going to the material findings.
Yes.
Since the petitioners, my lords get that, since the petitioners are the beneficiaries of acquisition, they were entitled to be heard during the course of an inquiry before passing the impugned awards under section 11 of the Land Acquisition Act, and consequently, the impugned awards which have been passed without providing any opportunity to the petitioners are violative of the principles of natural justice, and the same deserve to be quashed on this ground also. Then, Lord, there are various other grounds which have been given by the learned single judge. Learned single judge, Lord, finally says that the land acquisition officer cannot shift the deed. Lord, in all cases which have come to this court or the high courts till today, there is no preemptive, Lord, direction like my learned friend is seeking today. Preemptive direction is shift the date and pass an award. This has never been given by any court. Courts have not examined the award and then said, no, we are shifting this date for XYZ reasons. And after considering, now today I was not even heard. Now, not today, when your lordships are considering shifting of the date, not any high court after the land acquisition officer's award, I am entitled to be heard to show that this delay is not attributable to me. I am a beneficiary. I had taken steps, including filing of writ petition, etc. All that, Lord, is not on record today. So I'll have to bring that on record, show to Lord the constitutional courts, all that is done, and Lord, the constitutional court would then balance the equity. Today, Lord, what has happened is, in the meantime, the division bench also, Lord, agrees with the learned single judge. They say that the law on this point is that the constitutional courts can only shift the date, and this can be done after the land acquisition officer has passed the award.
How can that be done? After you shift the date alone is shift. Then the relevant market value will have to be decided.
He determines.
That has to be done in your presence. But how can just the date be shifted?
Shifting of the date is not under the law. The date is 2000, whatever. Date of section 4 notification.
So the constitutional court shifts the date.
Whatever date the
So
court
what happens after that? On that day, what is the value? How do you decide?
that is what the land acquisition officer will calculate.
Yes,
the market
decide
value.
that.
Hello.
No, it has to go back. It has to go back to him.
Hello.
Go back to LAO.
And that time we will hear you.
He'll hear you.
Look, here when the award was passed, I was not even heard. And what about the balancing to be done? Look, balancing to be done.
SLAO cannot shift the date. Constitutional court
cannot shift the date.
So the matter will come up after he is determined in some form or the other.
Yes.
And that court will say, no, now we are advancing the date, as the court says in Ramchan. Once the date is advanced, now you decide, take the
Correct. Now here,
exemplars.
look, here the thing was just opposite. SLAO himself shifted the date. Could the SLAO shift the date? That is what the learned single judge was considering. It was not his prayer that you give me 97 award or 2003 award. That was not even his prayer in the writ petition. He says closest to the award, 2019, 11 date he has taken. But tomorrow I have to be put to notice on that if the High Court is shifting. Otherwise, today on this pleadings, if it is shifted, please have a look Lord, at page 234 for a minute. What all I have said. 234, please see paragraph 14. And all this I have to enlarge and show it to the learned single judge, Lord, that or whichever the constitutional court is considering. Before adverting to the rival contention, necessary to refer to the undisputed facts leading to the present petition. On 3/4/97, FWA was entered into between petitioners and first respondent state for implementation of the BMIC project. Subsequently, on 14/10/98, petitioners have entered into an agreement in this regard with the KIADB. During the period from 98 to 2009, preliminary notifications were issued by the state under section 28(1) to the extent of 344 acres. Between 2003 to 2009, final notification under section 28(4) were issued. Between 2003 and 2012, possession of the lands were taken by KIADB, handed over to the petitioner number 2 at possession certificate. Petitioners issues a letter to the KIADB requesting them to pay compensation by passing awards. This is what my conduct is. Since KIADB does not pass any awards, one more letter was written. Since no awards were passed, I filed a writ petition number so and so, were filed with the petitioner seeking direction to SLAO to pass awards. On 29th November, this court allowed the said petitions and directed SLAOs KIADB to pass awards within a period of 6 months from the date of award receipt of the copy. In IA number so and so were filed so and so seeking extension of the time stipulated in the aforesaid order dated so and so. On 18 December, this court extended the period to 2015. Contempt proceedings were initiated by petitioners in CCC number so and so were withdrawn with liberty to file fresh petition if the need so arises. On 31st March 2015, one more application was filed by the SLO seeking extension of time yet again. The said application was not pressed. On 1st July, SLP came to be filed against the order passed by this court and the petition was dismissed and withdrawn at the instance of KIADB. On 27 September 2016, KIADB filed one more application wherein so and so, once again seeking extension of time. Again, even this time application was so and so, was not pressed. On 4th of October 2016, IA was filed by so and so seeking clarifications regarding deposit to be made by the petitioner in terms of the agreement dated so and so entered into between petitioners and KIADB. But this court disposed of the said application making certain observations. Meanwhile, the state had filed review petition seeking review of this court's order. passed by order. It dismissed the review petition. Subsequent to the aforesaid litigations and order, SLO started passing the awards between March 2018 and June 2018. Awards were passed in respect of 194 acres out of 344 acres, amounting to 53.72. On 3rd November, aforesaid awards were sent by KIDB for approval to state government, along with a letter dated so and so. The KIDB withdrew the said letter stating that the Chief Secretary had put up a note that if awards were passed, the defense of the state government before apex court would be weakened, and that it was necessary to obtain opinion of the Advocate General and proceed. Meanwhile, contempt proceedings, again I filed contempt proceedings. Incidents were filed by the petitioners by order dated so and so. This court directed notice of the application for implement of CO and EM of KIDB. As a party to the contempt proceeding, on 9th April 2019, the contempt matter was adjourned pursuant to the submissions made by the learned AG that the award should be passed within a period of 2 weeks. On 16th April, learned AG rendered an opinion that awards have to be passed in terms of the earlier proceedings, events and orders. However, in the said opinion, it stated that while passing the award, the market value as on date has to be taken on account of enormous delay in passing. KIDB forwarded the opinion to Special Deputy Commissioner, directing them to pass the awards as per the opinion. On 22nd April, SOs wrote letters to the special raising certain queries with regard to passing of fresh award and the compensation to be calculated in lieu of the awards already passed by them, sent for approval. In response to the said letters, once again addresses letters to instructing them to pass the award as per the letter as directed in the letter dated 16th April. On 22nd April, 4th respondent SLO passed the interim award in respect of 126 acres, 36.64 guntas, amounting to rupees so and so crores, and sent the same for approval of the state government. 5th respondent passed the interim award in respect of 115 acres and sent the same for the approval of the state government. On 24th May, the state government granted approval to the said award subject to. Now, please see, my lord, in this case, I have filed petition. I have written letters, please pass the award because I am a beneficiary. Tomorrow, the whole thing will come on me. I have filed letters, I sent reminders, I filed writ petitions.
Four protagonists, government, KADB, beneficiary, landowner. He is caught in the crossfire. You are not putting a house in order.
Look, somebody has to
Who is
manage.
appeal for the KIDB?
But that's very fine.
Then you will have to bear all this. You can't keep take somebody's land and don't take any action for 15 years. Right to property may not be a fundamental right, but it's a constitutional right.
If I name was taken. Dismissed, my lords, on the 5th of June 2011.
Maybe, but was there a stay? You have taken possession in 2005. From 2005, you are sitting idle. July 2005.
After the request was disposed, the acquisitions were updated. And the actual by the response.
And for what were you doing from 2011 to 2019?
For the limits.
Had it been an acquisition under the Land Acquisition Act, if the award was not passed, everything would have gone by.
That in the instead of to this whatever my pass and award accordingly. As well, we have taken the atom of final of the approval of the acquisition came to an end, my lords, in once the King's department handed over government charge, my lords, start the development.
What about 2011 to 19? Why should the farmers suffer, or whatever, they are saying that they are retired employees. Why should they be made to suffer? For the inaction on the behalf of the KIDAB? If you are in a slumber,
As a beneficiary, I had taken all the steps. I filed petition, letter, contempt, everything. I could not do anything more than that. I'm a commercial man. It can't be that after a few years, not that I'm.
maybe a commercial man, but they are the poor investors.
Absolutely. They have
So-
to be protected.
so-
I never said they should not be. They have to be protected.
So-
In fact, I told my learned friend also, I'm not against him.
So between you and the state, you may work out your.
You will have agreements, no? The beneficiary.
But I have agreements, but normally the compensation I have to pay. Nobody knows that. it's happening.
Any reduction will come to your benefit. Any increase will come again on you.
No, the whole problem is when the constitutional court decides, it balances the equity.
That is why you had a procedure where without resorting to this, you could have gone under the part 7.
No, I do not. This is their project. This is their project. 344, I can't. I'm only one of the allottees in that.
No, as a company,
Agreement.
there is an agreement, old act had an agreement.
Old Act agreement.
That is,
The second point regarding 2013 Act, that doesn't apply. That is the judgment. May I just point out? 2013 Act, that judgment is concluded.
That was on lapsing, but I didn't address that, but that.
No, I'm showing it.
Decree was on lapsing point, not on the compensation point. I am not arguing lapsing. And I am not relying on 24 for my submission.
Compensation also. But please have a look at this judgment. 2017 3SC. But please see page 317 first. The question of law, I will get that. Page 317, beginning of the judgment. Question of law that has been raised in this appeal by the appellants for consideration by this court is first, whether the provisions of the right to fair compensation and transparency in land acquisition, rehabilitation and resettlement 2013 are applicable in the instant case when the land is acquired under the provisions of the KIAD Act. So not directly on the. Now please have a look, not at paragraphs. Please see paragraph 30. I'm only taking the relevant provision. 34, please see page 328, paragraph 34. The KIAD Act, my lord, paragraph 34. The KIAD Act 34 is on page 328. The KIAD.
that is an extra.
That is an extract.
From Nagabhushan.
Yeah, because the last paragraph is 33 of the judgment.
No, I'm saying read 328, para 34.
That is
It's an
extract
extract
from
of the earlier judgment.
Nagabhushan.
Correct. And that refers to Girnar traders also. That's why I'm reading that. The KIAD Act is of course a self-contained code. Said Act is primarily a law regulating acquisition of land for public purpose and for payment of compensation. Acquisition of land under the said Act is not concerned solely with the purpose of land development of it. It has to cater to different situations which come within the expanded horizon of public purpose. Recently, the Constitution Bench of this court in Girnar Traders versus State of Maharashtra held of the Maharashtra regional of the old land on the parity of reasoning, provisions of section 24(2) of the new land making 11A applicable would obviously be not applicable, and we would like to judgment.
That is why Ramchand line will apply.
No,
See,
that
you
is
just-
the principle.
You forget the 1984 amendment to the Land Acquisition Act. Let us go to the Land and forget the 1984 amendment.
On principle, I have no dispute.
What happens to delayed acquisitions
No, not
under the
principle-
normal land
No,
acquisition?
not principle, I have no dispute. But the argument that 2013 Act would apply, that Lord, I have a little this one. Because then I can show, merely because General Clauses Act applies, if KID is a self-contained code and it has provisions for everything, and the benches have taken views, not one, not three the benches have taken. Girnar traders in case of Maharashtra is not found any, KIDB in case of this Anusuya Bai also, and the earlier judgments. And number two, not insofar as balancing of equity is concerned, shifting of the date, obviously they can't be put to gross injustice like what has happened in the present case. I am a beneficiary. I am showing I have taken all possible steps. Beyond not giving them letters, reminding them, filing petitions, finding please pass over. What is going to come through? When the constitutional court balance. Look, today when your lordships are taking a holistic view of the entire matter, say that injustice should not be done. It can't be, Lord, should not be done to him, and Lord, I should be made to suffer despite taking steps in law. Beyond this, I could not have taken any more steps, my Lord. When the land is allotted to me, I'm doing work on that. I can't even give back that land at this stage. So I would be put in a very precarious situation that for their default, somebody else pays. And Lord, that is surely not the law of the land. Therefore, when your lordships consider this, please consider this aspect of the matter also.
That is interstate between
You and the KIT.
Must be having some arrangement where there is.
If your lordships once hold, then they will say you pay. If I have to not suffer, then my things should be kept open that I would be able to discuss.
Must be having arbitration clause in the.
But that your lordships know. I'm only saying when your lordships lay down the law, that it has to be compensated. Compensation by the defaulting party. If it is attributable to me, definitely yes. I failed to deposit. I don't. Here I have taken steps. What else not a party could do? Because party beyond this plot can't do anything. Beyond filing contempt against them. That please pass awards. Writ petitions. High Court issues directions. Do it within 6 months. You file applications after applications to 3 and 11 to 19. Surely there is nothing.
No, see, right now, any compensation will be paid by the state only.
By the state.
They'll ask me to pay.
That is when they ask you, you have to take your
I
approach.
can't. Thereafter the defense and arbitrate.
Of course.
Lord, what I'm saying is there are two ways. One is either your lordships today protect me fully, or the other way is that tomorrow when they fasten it on me, when I raise it before arbitration also, that's right, to protect my rights. That's right. My rights should be protected.
Turn the liability on them.
Lord, and your lordship will say
And then if they ask from you, at that time you may pursue your remedy.
So
Why should they be deprived of it?
I'm not saying they be deprived. I never said that Lord, they be deprived. They should be compensated, there is no doubt. But what I'm saying is it should not be attributed to me.
We'll clarify that. That you are taken the steps as both you as well as they have taken the step.
I have taken this step.
No, they have also gone to the courts earlier.
Later. They went to challenge it. But they went to challenge it.
And their alternate also prayers were there. 2009 I have been in litigation. I have been running from pillar to post, my lord. These 35 petitioners, their representations for alternate sides.
So they would from 2009 they have also been taking steps. You have also been taking steps. It is only they who are sitting at
Absolutely.
in a deep slumber.
So in these circumstances, I should be protected. My rights should be protected.
The lordships are well in land acquisition matters. Financial burden can't be pleaded, my lords, against the landowners. My lord.
What did we say?
Yes, my lords. I am very grateful, my lords.
What were you saying? Were we saying something different?
No, I am only saying because it was being argued so
No,
strenuously.
but he is also right in saying that he also cannot be penalized. If the state doesn't take action if the KID sits idle, he is only seeking protection of his interest.
Only on the issue
Now,
of
what interest we can protect yours? It is you who is the culprit. Have you given to them? Are you willing to give them alternate piece of land now? Are you willing to give them equivalent pieces of land? You take instruction.
Framework is between who and who?
between RCI and
Project proponent, nice.
That is what Mr. Chandrachud already read, that they requested you, if you are not in a position to give compensation, give us alternative site of land. We are aware about that, but are you willing to give? Come at 2 o'clock.
There are 11 acres of land under this award. I am doubtful, Manoj, they will give alternate site in the Bangalore city, Manoj. 11 acres of
11
land.
acres in
This will be a futile exercise, Manoj, after arguing so long, Manoj.
We are not shunting of the matter. We are only asking them to come by with instructions by
Very
2
well,
o'clock. No, sorry. Otherwise, we'll close the matter. No, not tomorrow morning also. No, we can't take, the now new arrangement is today's matters won't go tomorrow.
No, this is Tuesday, Wednesday, Thursday.
No.
All right.
Tuesday fresh, Wednesday fresh, Thursday fresh.
Then Lord, I thought the whole idea was to finish the NMDs.
New list every day.
I am appearing for the state.
But every system.
In this, because I am appearing for the state and only regards because with regard to the shifting of the date and why that power is not given to the state government of the SLO as a matter of policy, that part, and today, the petitioner's rights are kept open, which is what the observation in the single judge and the division bench. Yes, yes. No.
Absolutely. Entire power is with you.
The power of shifting of the date.
Shifting is only with you. Court is using its other constitutional powers to use it. Otherwise, you resigned an issue. That was the whole purpose. You can't peg the price on some day and prolong.
The reason why in Ramchand's judgment it says that it's not given to the state is because only in exceptional circumstances under 226 and 32 the court is empowered to shift the date.
Not that is not available to state. After 4, 6 comes, 9 comes, 11 comes. Once they do that, 4 can't be.
And for the other reason, it will create havoc because imagine vesting the power into an authority with utmost discretion to shift the date. They are statutory bodies under KIADB, they should not be vested with that power. So the exercise of whether the date should be shifted and who should bear the burden and to what extent it should be shifted is the exercise which has to be argued de novo again from the SLO up to the Honorable Supreme Court, which is
and then the matter should reach finality when
my lord
in the next 25 years.
I have a short note to assist your lordship. Just to assist your lordship on this. No counter was filed.
You are having with the state.
Yes, just I'm only on the legal position because their interests should be fully protected and because the interests of my learned senior also should be fully protected and who is to bear, but to what extent that exercise has to be done on the basis of arguments. Who has caused the injury, etc. All those submissions.
That you may have whatever remedies are available in law.
May I just give this for record, for the court? Your lordship will also have the finding in the imputed order para 9 and para 17.10. Both the findings in both those pages note this exact proposition of law falling from Ramchand and the other judgment. 17.10 your lordship will only note at page 278 and paragraph 9 at page 17. Yes, yes, because the state cannot, the state cannot do it, because that's the proposition which is noted, because that paragraph, your lordship will kindly have paragraph 9, because at page 16 it starts.
Page?
Page 16, because paragraph 9. Yeah. So that's the Honorable Division Bench's judgment, which affirmed the learned single judgment. And this is a public project, Bengaluru to Mysuru project, which is a long corridor which will be built. And there were several stages at which this acquisition was challenged. So, sometimes at some stage, it will also be looked at whether it is their fault or their fault, or whether the court, interdiction by the court was also responsible, because it went up to 3 rounds of writ petition for filed.
So some share has to be.
No, I mean, that obviously caused
So,
the delay, because
so all those judges will have to be made as party respondents. Who were at some point.
May I just read paragraph 9 for your lordship? Further, the learned single judge held that the SLAO has to determine the compensation as on the date of issuing the preliminary notification as contemplated under section 11 of the Land Acquisition Act, and not to shift the date to a later subsequent date. The learned single judge has set aside the award passed by the SLAO and directed the SLAO to reconsider and pass the award. The grievance of the petitioner regarding shifting the date at any later date or subsequent could be considered only if the award is passed by the SLAO. The SLAO has yet to pass the award. The grievance raised by the petitioner in the writ appeal is premature. If the petitioner is dissatisfied with the award,
How is this finding a correct law?
the reason why, because
The award was already passed. That was challenged by Mr. Nadkarni's client.
the award was challenged, it was set
By you
aside on
subsequently. By an afterthought.
It was set aside on 4 grounds, 4 other grounds, not on the date.
So what will the SLA do on the date, Mr. Avishkar? Just tell me.
When the single judge directs that such and such date has to be taken into consideration, is the SLO left with any discretion?
Single judge then.
Competition, but pay the price at 2003.
Then the date would be shifting.
Who should shift the date?
The Honorable
The
220.
single judge says that the date can't be shifted by SLAO. The High Court, the division bench says that it is premature.
The reason why was because arguments possibly were canvassed at that stage. So if the computation on the shifting of the date.
You want us to be sent it back to the single judge?
I only said this was a remand where the petitioner has succeeded today.
Remand?
The petitioner has succeeded and he's coming to
So
you.
remand what? Remand by directing everything to be taken away from them.
Principle is decided now. No?
Only respectful submission. They remanded back to the SLAO to pass the award, and in the event they were satisfied with the correct date as it was pegged by the SLAO, they could come to the Honorable Writ Court for the.
Whether the SLO had a discretion to change the rate?
No, as per law, they do not.
No, as per law and after the judgment of the learned single judge.
As per after the judgment of the learned single judge, also no, because that.
Then this finding that it is premature is wholly wrong.
Subsequent award, which will be challenged again, and then date
Yes.
could be shifted.
And then they should wait till 2050. Okay, to see. The award is passed, then they should challenge it before the reference court. Then after reference court, they should go in a first appeal, then High Court, and then Supreme Court.
Have you paid the undisputed amount without prejudice? Have you paid nothing?
They have, I think, deposited in May 24. I think they have deposited to
But
stop.
we have deposited.
To stop the interest. But that award is not binding on.
31%.
That's an award pursuant to a single judgment.
In terms of the award, and then subsequently the single judge set it aside. The Honorable Division Bench has also affirmed the single judge's order.
Then there was another award.
Yeah. 6 crores inclusive of interest and all component remains.
Remains there. So at least to some extent.
So that we deposited immediately.
That was set aside.
No, the 2019 award.
That is set aside. No? That award has been set aside in any case.
Yes, but the amount under that
Amount
under that award is already deposited.
After the impugned order, Mr. Nadkarni said there is an award.
That brings it to 2 crore something from 56 crore.
Correct. Has that been deposited?
That has been, they have never issued
That's the old.
Old award. So that is gone. That is gone.
No,
No?
but that continues in deposit.
That
gone.
The foundation for that is gone.
Money remains with them.
The foundation.
Money remains.
I will pray in those last 4 directions in my page 8 of my written submission. Otherwise, there will be great prejudice to him. There's only one prayer, Manoj, which I'm making. In 42, but sending the matter back, these submissions made by the other side, Manoj. Since 9, I've been in litigation for this, 2009. After possession taken away in 5.
2019 to fake he direct the award to be what is it? Say wrong statement.
I'm very clear.
You can give it. Don't make it too lengthy.
Just a small. I'm only asking for protection.
We are protecting, we are making it clear. We will fix up a date which meets the equities. We will say that the amount will be paid initially by the state. And if the state demands from you, then you will be entitled to raise all your grievances as you have raised in the equity.
Only on the notes on that equity to states, etc. What I have done.
That we have already noted. Because that you are to page 234, you have already raised that.
That's fine.
If you want to give, you may give it in.
List of dates, the comprehensive meeting.
List of dates, Mr. Chandrajur's list of dates is already comprehensive.
Right, Krishna. I picked up the Police Welfare Confederation. In my respectful submission.
Service is incomplete in respect of item number 7, 7.1, 7.2, 7.3.
This is the 3C matter, where my lords have kept it 3C. 3C filter. The order of the NCLAD may have to be set aside and the matter may have to go to NCLT. The proceedings will have to continue.
No, the service is not complete insofar as some of the respondents are concerned.
That comes in the office report, but since there are cross appeals, everybody has.
Everybody is here.
Although your lordship is right, the office report does seem to indicate that.
Your lordship, but rightly directed, it is to be taken at the top of the board, Millard, because this matter have been here for long. And there are multiple appeals, Millard. I am appearing for the home buyers primarily.
The home buyers
and they are the directly affected parties.
Before NCLT.
In fact, last time,
Because the project is of 2011, we are in 2024, Millard. And nowhere the construction is happening because
and the IRP is also here, Millard.
Because of the problem, because of Millard, the joint venture between the two parties, Millard, 3C and Oris.
Mine is the first appeal, Millard. If I may place it.
And we are affected.
My lord had asked last time.
And of course, to point out that there is a chart also, there is a multiplicity of matters and the parties are common. And of course, the lordship takes it up, I'll share that chart. The lead matter, which seems to be the side that the senior on this side, where the officers arguing, which is one of the welfare associations of the home buyers.
The home buyers confederation.
For the confederation, we call this welfare confederation. Ultimately, what is going to come, just as an overview, is to see, lordship, three things. One is the IRP's reports, which were made pursuant to him being appointed by the NCLT suo motu, pursuant to him giving all the NCLT's direction, verifying all the claims, putting them in three status reports, and those three status reports point out who are the creditors, verified claims, what is the modus operandi of this CIRP proceeding by the 3C group across several companies. Lordship, if I may point out, thereafter, Lordship, what I would show is how some of the arguments that are being taken have already been considered in dismissed appeals being foisted by the promoters or other related parties.
Against the RP in direct violation of the status order granted by the.
Yes.
The 3C group is gaming the system
and Milord NCLT and NCLAT are being taken for a ride, and the impugned order, Milord, is clearly an order which needs to be set aside, and the proceedings will have to continue before NCLT.
One sentence to add on that, till I need the status reports which show the complete true and picture about this collusive behavior of siphoning of funds, taking funds from the home buyers, siphoning it off, transferring the assets to sister concerns, and then starting an IBC proceeding in which a client RB is put. Till then, there was no problem. After that, consistently, the arguments have been against the IRP, but no challenge to the status report. Those have been duly considered, are lying there. If I have much to say about when I have my
I am for 850 home buyers, Manoj. I am the most affected. The status report is filed after the CIRP set aside.
Colluding with 3C,
Nirmal Singh. May I just speak? This status report is filed after the CIRP set aside has been fraudulent. Manoj, my lords had asked for a
what is
list
the local railroad and appellate?
Manoj, may I just hand the floor a list of all the effects?
also told the NCLT that it's sort of
Let the matter be heard in a systematic way.
In this manner, can we start with the hearing of the matter?
Let the appellant should argue first, Milord.
Let it go. Very humble suggestion. Let it go sequentially. Item
Yes.
7 first, 7.1 first.
Yes.
That perhaps is the only way, not otherwise everybody will be speaking over everybody else.
We agree.
But this is all the list of parties also, Manoj. We made a list because it was very difficult to come to who will speak first, etc. So we made a list of parties also.
I also carried one.
How much is your
According to me, the question of law is now decided in Milord, in the Byju's matter. Therefore, Milord, once the proceedings are in rem, without even hearing us, if Milord, the sub proceedings have been set aside, Milord, surely Milord, that will have to be restored and the matter will have to be heard. If they want to move an application, Milord, NCLT will have to consider it. Milord, the NCLT proceedings will have to be restored. NCLAT order is clearly contrary to the law laid down by my lords.
Unlike Byju's, this is a case of fraud. Unlike Byju's, this is a case of fraud, Manoj. There's a big difference.
Fraud is by the 3C colluding parties. And Milord, that very order was challenged. Milord, a coordinate bench of NCLAT said there are 22 other creditors whose interests have to be protected. That order is not even considered in the impugned order. A coordinate bench has taken the view, very same Milord, argument was advanced.
Your Lordship has to see what is the impugned order, Milord. The impugned order is only of collusion.
What issue is, Milord? It's an elementary issue. If, Milord, a creditor files a petition, either in winding up or in IBC, either way, Milord, the law is that if that creditor is either collusive, or he withdraws, or he settles. If there are other creditors, they are in the wings. The petition doesn't come to an end. Therefore, other creditors, Milord, will come over and take it over. So if, Milord, the present creditor is held to be collusive, petition is admitted, if he is out of the picture because of collusion or whatever, we are other creditors having, Milord, hundreds of crores worth of, Milord, debts. Therefore, we will step in, Milord, the IBC. Then there will be a resolution plan, etc. That's the procedure.
1100 home buyers whose interests are at stake.
There were 22 other petitions pending that day. They are staying in the wings, Milord. It's a rule, Milord, of 446 of the Companies Act. Same rule. Once you are in rem, if that petitioner, Milord, goes away or whatever, the others will take over. That is all there is. And Byju's case has said so, Milord. It is actually a principle of the 1956 Act.
Lord, I am appearing for the appellant in 7.1. I was the operational creditor. On my section 9, the first order of admission of CIRP was passed. All these allegations of collusion, etc., were made against me. Notwithstanding the fact, as Mr. Vaidyanathan pointed out, that by a previous order, the Honorable NCLAT, 6th of January 21, had dismissed these allegations of collusion against me. Despite that, not by the impugned order on 23rd of August 23, my appeal is dismissed for non-prosecution. Even though I had been heard on previous dates, I had filed an appeal saying that after CIRP order had been passed, on applications, the NCLT had returned a finding of collusion. So I filed an appeal saying, please expunge those remarks against me. That appeal was dismissed for non-prosecution.
Milord, whether he is in collusion or he is not in collusion makes no difference because other non-collusive creditors are standing in the wings. That is all there is to it.
Yes. CIRP have to continue.
Yes.
We are all in agreement on that.
We are not, Manoj. All of us are getting two promoters who had promised to do a project, are fighting amongst themselves. 850 home buyers are today in difficulty.
Again, paper book then.
Yes. ED has conducted very.
And Manoj, that CIRP, collusive CIRP is the one which shows that Manoj what's happening.
Even if it is
So-
collusive, it's not.
Yes.
Who is one of the person who is 35% of the financial creditor is driving the CIRP. Because what is pretty expected what is who hires? CIRP and by corporate insolvency that started. It was for the actual resolution of the entities, of the people getting their amounts. It cannot be a fraudulent process which is instigated. And what
Ask for CIRP.
Actually see within
Great, Manoj.
How about you start?
Great, mate. That may start my appeal, Manoj, to look into
Yes.
797 of 2020.
That's the first appeal.
Yeah.
That's the first appeal and let it be started, Miller. The
Yes.
impugned order.
But can we have for my lord's convenience, we have a convenient compilation, so that we don't have to go to any volume. Yes. Yeah. 697. Yeah. 797.
It's a 6792.
First is 679.
Deal man.
So Vaidyanathan, how much is your estimate?
I will take about 45 minutes to an hour.
But if it is not likely to be finished today, then we may not be in a.
It can be.
Supposed to admit it.
This is a matter.
Well, I think there is a short way of disposal. Well, according to me, the impugned order
Yes.
is without hearing all the affected parties. Well, that cannot stand. Then the question will be whether it has to go back to NPLAT or NCLT. In my respectful submission, well, it is in the interest of having the parties if the matter goes back to NCLT. Then the sub proceedings will have to continue, and if anybody wants to do an application, otherwise it can be done. That NPLAT order cannot stand because on the very same question, the earlier coordinate bench of NPLAT has taken the view that the initiation of proceedings, admission of proceedings is valid. Therefore, this order is clearly wrong and it has to be set aside.
Where is that?
I don't think it needs to go back.
Where is that order passed by the?
Yes, sir. Would you also kindly have a look at the order? Then the order which is passed earlier order passed, that is 15/4/2020. I'm sorry. 6 January 2021, page 34 of the convenient compilation.
This was passed in appeal 891.
1-1.
891. It's document 6. Page 34 of the convenient compilation.
Specifically allegations of collusion.
That is saying
Can we hear one at a time? If it is not inconvenient to everyone.
page 34. The Greeno Police Welfare Association.
Page 34 of volume 1.
Of the compilation, volume, convenience compilation.
We have convenience compilation.
Documents.
Has it been e-filed also? E-filed also? PDF? Oh, there is 7, then there is 7.1, in which you have filed it. Item 7. All right. Yes.
The specific argument of alleged collusion is dealt with in para 9. The order is page 34.
Yes, Justice Chima's order.
Yes, sir. That's right. That's right. That's right. Now that apparent is Union Police Welfare Association, which claims to be representing some of the home buyers. Now that the specific argument of collusion, paragraph 9 at page 43.
So if you don't mind, please, there are 7 also.
Please. Yes.
There are 7 is most important, Miller.
Let para 6 first.
Yes.
In the present matter, 1 and 2 are now both under service. Both represented through different insolvency liquidation professions. There are also IS 2742 and 2743 filed by company named Orissa Infrastructure under Rule 11. So of the rule seeking intervention. There is IS also by one rural and Loma claiming to be representing 120 home by seeking intervention, claiming that the work should be continued. Before proceeding further, it would be appropriate to make brief reference to the developments before the present impugned orders and also developments which have taken place after the impugned orders, as well as during the pendency of the appeal. We are making short reference chronologically for appreciation. Well, since I want to make a brief submission, I am not reading all this and going straight away. The alleged collusion, para 9, because that argument is dealt with and when it is rejected, they say other home buyers, other creditors. Yes. And please see page 43, para 9. We have heard counsel for the parties. Counsel for the appellant has made submissions on the above line and wants the impugned orders to be set aside. Counsel for the appellant claims that there was collusion between the two respondents and thus the admission order was bad. The counsel claimed that respondent number 2 is not an operational creditor as respondent number 2 had in the matter of Gupta taken defense, which is contrary to the claim made in the present matter as operational creditor. Reference is made to the facts of that earlier matter, and it is argued that the admission order dated 26 February 2020 in the earlier matter recorded that the amount which was owed by the respondent number 2 had been assigned to person number 1. It is argued that this shows that the present respondent number 2, operational creditor, was acting only as an intermediate. We have seen the said order dated 26 February 2020 and the defense which was taken by respondent number 2. It has to be remembered respondent number 2 was corporate debtor in that matter. Para 14 of the earlier order recorded the defense of respondent number 2 in the earlier matter that it had entered into agreements with 3C shelters, present corporate debtors, and 3C projects collectively called principal employer. Defense recorded in para 14B in the earlier matter was that the corporate debtor submitted that the debt of the corporate debtor had been assigned to the principal employer of the corporate debtor. Appellant is banking on such defense recorded in earlier matter. On such basis, collusion fraud is alleged. We do not find any substance in such averments made by the appellant. Present application under section 9 is undisputedly filed by respondent number 2. definition of financial control, those who set out, then serve against respondent number 1 is maintainable. Order dated 2020, that is order 1610, and then please see paragraph 13, page 47. The grievance of the appellant appears to be that it was the biggest financial creditor, and instead of acting on its application of respondent number 2 was admitted. How does it matter? Ultimately, the serve proceedings will have to go on. Prior day of the appeal also indicates that the appellant also wants serve proceedings against the respondent number 1 corporate debtor. IRP of respondent number 1 has the direct number also. 5 list of company petitions which are moved by stakeholders, including home buyer, against the present respondent number 1 corporate debtor. It is a list of 22 petitions in which it appears that the appellant had also filed CP number 1335 of 2019. Sumita Gogoi, who filed IA number so-and-so in this matter, was another petitioner with company petition number 503 of 2019. Intervener Dhruv Verma also wants self to continue. Even if we set aside the impugned order, there are others waiting against respondent number 1 corporate debtor. When respondent number 2 as corporation creditor filed petition application under section 9 of IBC, the only consideration for adjudicating authority was to examine if there is operational debt due and default. It found the debt due of rupees 29 crores 95 lakhs 91,034 was not disputed and passed impugned order dated 20th July 2020, allowing in such matter, after petition was allowed, adjudicating power had no power left to review the order. Now, this is the contrary view is taken in the impugned order. Had no power left to review the order dated 20th July 2020, especially so on vague surmises of pollution. We do not see any purpose of setting aside on technical grounds the SERP initiative. Order dated 16th October 2020, by which order the adjudicating authority as recorded reasons thus showed that there was material to show debt due claimed by respondent number 2 operational creditor and default to seek SERP against respondent. If the application was complete, same was required to be admitted. Then they go on to show both are now under review. Trust IR will follow the IBC. Yes. Yeah, I'll go to the includer.
Is filed 22 petitions, that one case time order. Subsequently, the status report of the ARP is 1100 genuine claims. Before and after. This 29th March 22, the NCLT returned the finding of collusion. One bench says that it's an interim order, the second bench says that it's they specifically said that my debt was due. They specifically said.
That's the problem. Page similar 265, in the same volume, 265. Extraordinary. Not even considered, and says that the NCLT had the power to recall, should have recalled, it is collusive, and Miller doesn't consider that there are other creditors, and there is an earlier order.
And this order of Justice Chima is not challenged here.
Never challenged, it has become final.
Although, my lord, my appeal, I was this operational creditor respondent 2 in this order. Although my appeal was dismissed by the impugned order for non-prosecution, but this earlier order of 6th of January 21 was on record because I filed it in my written submissions.
Now, kindly see whether the impugned order, which is at page 265, document number 50, same volume.
Page number 274 is with para 20.
CRP proceedings are initiated.
Yes.
They are challenged by some persons.
We challenge.
Whatever it be. That challenge is negated
Yes.
by a speaking order.
Yes.
Thereafter, somebody files an application for recall of the order for initiation of proceedings. That application is rejected by the NCLT. So in view of the earlier order of 6th of January,
Yes,
how could the NCLAT
yes.
sat in an appeal over that order?
My lords, there is one.
Isn't there something like judicial property?
Yes, my lords, one aspect. The issue, the collusion point which he's raising was a different aspect.
Might be.
Yes,
When one court,
yes,
one bench of one court
yes,
gives it imprimatur
yes,
that the order of CIRP,
yes,
initiation of the resolution proceedings,
yes,
is not liable to be challenged,
yes,
or the challenge to that is not sustainable,
yes.
whether the another bench could have sat in an appeal
My
over
lords,
that.
what happens is, in fact, NCLT's order, para 51, distinguishes.
On the
Subsequently, certain frauds come to the knowledge, and that is why it is set aside. My lord, that's why the CIRP is set aside on a totally different ground. Ground is that
then
3C
that everything should have been gone into by the NCLT at the first instance.
Yes, that's what it has
People
done.
are who has filed the appeal. The appeal in the impugned order.
Can I now
Impugned order is an appeal filed by Rakesh Kumar Gupta, who is a resolution professional of 3C Universal Developers, which is the promoter company.
The 3C fraud which
Well,
is
extraordinary.
My lords, may kindly let me say. The 3C fraud which is subsequently brought on record is there are pantry boys who are directors of 3C who are operating. And on that basis, my lords, at para 51, NCLT notices these subsequent facts. On that basis, on that fraud, it is set aside. My lords, we are home buyers, we are not worried about CIRP, etc. But our plots are in 857, I represent home buyers. Because of this delay in CIRP, etc., my lords, this is all, I am stuck between two promoters fighting. My lords, we see para 51. Of the NCLT.
No home buyer can be agreed by the serve process.
It is
Everyone has to get the.
And my lords, and the IRP in this CIRP is, my lords, filing a status report after the CIRP has been set aside. When and also moving to the High Court for orders regarding assets regarding which a status quo has passed.
Status quo here.
Yes, yes. And he's gone to the High Court, my lord. This IRP goes to the High Court and starts asking for directions with the High Court. Unfortunately, has passed directions on this aspect.
Justice Ashok Bhushan's bench specifically asked IRP to verify the claims, and Miller, that has been done, and that is what has been charged.
That status report is filed after the CIRP has been set aside. It has no sanctity. Yes.
Firstly, how could the another bench of NCLAT
Yes.
have passed an order contrary to the?
My lord, because
Let us see how it discusses.
yes, my lord, we see para 15.
Kindly similar.
Mr.
Mr.
Vaidyanathan, we have called upon him, so.
Yes, answer, very well.
Which page, Mr.
My
Sir?
lord, we see para 51 of the NCLT order. Unfortunately, we have our convenience compilation, we can find it.
It is not in this convenience company.
Page 41 of the appeal.
The order dated 28th of August 2023.
Deep view, deep view.
Para 51.
No, sorry.
No,
This is the NCLT
23rd of December 19, is it?
NCLT order, my lord, this is 29th March.
No, NCLAT order.
No, first the NCLT order, my lord.
No, let us see NCLAT order, because NCLAT has passed an order contrary to the earlier bench.
My lord, that's in the review process. Page 3.
That is
What page, Mr. Vaidyanathan?
265 Miller impugned order.
The same one.
Same volume, document 50.
But then the last paragraph of that judgment, para 27, so where do you get para 50?
Onwards, para 22 onwards.
The NCLT order, which notices that there is a separate set of facts leading to the fraud. It upholds, and it says because there is fraud, but since I have no inherent powers, I can't set it aside.
Wants to see.
That's why this.
51 of the NCLT.
Yes, NCLT order, my lords, is important because that gives the subsequent events which led to which is the basis of the fraud for the present setting aside of the CIR. Those facts were not to the knowledge earlier on. And that is why, my lord, I didn't know about it. I had filed that appeal. I didn't know about it, my lords. This comes into account in 51. Now, after.
Where is that order? Where is it?
NCLT order.
NCLT order?
NCLT order.
401. 401 of the appeal.
That's page 65.
Or 65.
Document level. Same one.
And we see para 51 where they notice the subsequent events, which forms the basis of this.
Para?
Para 51. What we see apart from may I read that? Apart from 3C Shelters Private Limited was being represented by Mr. Rajiv Basoria and Mr. Grish Chand Joshi, Oh, Madam, may I just start with 50? Sorry. I'm just, yes. That will give the full conspectus, madam. Para 15. Further, it is to be mentioned that the demand notice in the present matter.
No, it begins it further before embarking upon the retail. Para 50. Para 50.
Yes, para 50. Yes, madam. It says further, it is to be mentioned that the demand notice.
That's at 110.
Page 400 of the appeal, madam. My lords, it's 110 of the CC, para 50. My lords, would like me to read it, or my lords is
Yes.
yes. Further, it's to be mentioned that the demand notice in the present matter was issued on 9th October 2019, whereas the resolution of the Board of Corporate Debtors pertains to 24 June 2019, whereby Mr. Rajiv Basoya and Mr. Girish Joshi were directed to file reply. Hence, the company had already preempted that reply on behalf of the company must be filed with respect to the demand notice accordingly. Therefore, Mr. Rajiv Basoya and Mr. Girish just filed the reply in the petition. All these circumstantial evidence on the record indicates that there was collusion, active collusion between the corporate debtor and the petitioner herein to initiate the insolvency proceedings. Further, without any resolution on the part of the corporate debtor, some of the directors and petitioners herein got a memorandum of understanding dated 7/19/2019, even without involving Messrs. So and so, 3C Universal, which were actually parties to an agreement. Moreover, the said memorandum of understanding was not yet attested or registered. Therefore, the said documents were nothing but afterthought documents fabricated, created just to facilitate the initiation of CIRP proceedings. Further, the petitioner herein, without redeeming the securities, as alleged to have been stated to be secured by way of property, that is plot number so, proceeded to file the present petition. One of the erstwhile director, Mr. Suren Singh Suri, that is respondent number 4, categorically deposed that Mr. Bharadwaj, while deposing before EOW, categorically stated that his signatures on the memorandum of understanding were not genuine, which further puts cloud for the authenticity of the execution of the document. Further, there was no authorization or resolution of corporate debt in favor of Mr. Bharadwaj, Girish Joshi and Mr. Rajiv Basoya, for execution of documents of any kind with State Edge Contracts Private Limited. Hence, even the alleged agreement dated 28/11/2017 also comes under cloud. Further, the corporate debtor was having in its escrow account rupees 53 crores at that time, and the corporate debtor, despite admitting the liability, did not prefer to pay the same. Hence, the fact creates a serious doubt about the execution of the very first agreement. Now, let us para 51. Apart that, 3C Shelters was being represented by Mr. Rajiv Basoya and Mr. Girish Joshi, who were mere pantry boys or office boys of the company. Correct. To support the said facts, or is also placed on record their affidavit dated 24th February 2021 of the 3C Universal Private Limited. These affidavits clearly prove that these two persons were not at all aware of any of the activities of the company and they were not familiar with any documents, etc. Accordingly, they have also made requests to discharge and remove them from the directorship. Though some of so-and-so stated to be paid by 3C Shelters merely relied on the documents and no such other documents pertaining to the execution of the work at the site, which might include the balance sheet and other job works and sheets and list payment, etc., mode of payment were never produced. Absence of all these material documents further creates a serious doubt about the claim made herein. Pleading of the petition has merely been admitted by these dummy directors, Mr. Rajiv Basoya and Mr. Girish Joshi. Except this admission, there is no authenticated document to corroborate the fact whether the work was actually carried out at the site. Learned Rera also specifically held that no construction was going on Greenopolis since earlier 2016. Although the contention has been raised from behalf of SS State Edge contract that it was not a party to that application, the said findings, if any, recorded are not binding upon it. But in this context, it is to be mentioned that 3C Shelters was in fact party therein, and the said complaint as well as other proceedings were duly contested by them. Further, Learned Herald also recorded the same finding, categorically stated and under that the construction of the project virtually came to a standstill early in 2016. It is 3C Shelters which admitted the liability in the present application, and the said issue is also hotly contested by 3C Shelters before Learned Hera as well as Hera. Therefore, the said findings are very much binding on the petitioner. Also, herein also, and as the interest stands accrued to it, to the respondent corporate debtor itself. And my lords, 53. So far as doctrine of merger is concerned, it is to be mentioned that Oris Infrastructure, though filed an application for intervention before NCLAT, but the same was declined. Neither RP of the corporate debtor nor the corporate debtor nor Mr. State Edge had never arraigned Oris Infrastructure Limited as party in the petition. Learned RP of corporate debtor also did not prefer to disclose this fact to the tribunal. So the factum of collusion has been discussed by the Honorable NCLAT in the order dated 6/1/2021, but apparently the said contentions were raised by Grenopolis Welfare Association. Therefore, the finding therein, recorded therein in the said order does not bind Oris Infrastructure Private Limited. Even all these facts were not in knowledge of Grenopolis Welfare Association. Moreover, the Honorable Supreme Court in its order dated so-and-so 31/5/2021 has given liberty to Oris Infrastructure Private Limited to file an appropriate application before the tribunal, and parties were relegated to this tribunal to decide on these issues. Therefore, now it cannot be said that the order dated 20 July 2020 stand merged in the order of NCLAT dated 6 January 2021, and this tribunal stands barred to go through all these issues. So, my lords, the issue of what fraud was, the nature of the fraud, etc., was totally different there. These are subsequent facts which come to the knowledge. NCLT says I don't have a power to review to recall my order, so it leaves it, and NCLT upholds this order of fraud, says that you had the power and therefore sets aside the CI.
But now my NCLT doesn't discuss, it only says that it has the power to recall and we recall. But it doesn't, it doesn't discuss as to what fraud is there, how it is, it finds that the finding of the.
That it accepts these because it does not dispute the setting aside of the CIRP. Otherwise, there were hearings held.
Can we hear one at a time?
I'm sorry. And my lords, what happens is this. Now what happens is after this CIRP set aside, the IRP suddenly comes up with a status report filed before this court. On what jurisdiction, on what capacity, my lords, not known. And then, my lords, that status report, there is already a report of all the allottees, etc., which before RERA by a forensic auditor, which gives all the allottees which are there. My lords, we are not worried about it.
Mr. Sen, you tell me, where is the only consequence of 65 a dismissal? It may happen that the initiating party may have colluded.
Yes.
Otherwise, you can game the system.
Yes.
And then it turns out that in the process of admission that there are other genuine creditors.
Yes.
Why cannot the NCLT constitute a committee of creditors with the genuine OCs in a OC case or FCs in a FC case?
Yes.
Punish this man under 65, but let the CARP to continue. Otherwise, with 100 creditors, you will be first past the post with a colluding party, and then let the whole system set aside, leaving the others in the lurch. Why should where it 65 says, where it says dismiss the CARP?
Yes.
65 says penalize the colluding party.
The submission here will be twofold.
So you tell me,
yes.
Otherwise you see you can game this system.
Exactly, but the gaming which is happening is larger. Malad, the gaming which is happening is larger, Malad. What we are pointing out.
It's clarified that the stay would mean that the proceedings before the NCLT would proceed in accordance with law.
We are just we have denominated which is there. We are Malad, may kindly point out.
Yes, thank you. Next matter. We'll hear it finally, yes.
One clarification. One of the joint venture parties is using the pending proceedings and not handing over the flats. This matter should not come in the way of handing over.
So we are saying that the NCLT will proceed in accordance with, you get the orders from the NCLT.
Now this COC will have to be constituted.
Other joint venture party is obliged. Just one moment.
No, that the IRP will move section 60 subsection 5 application.
The second order of NCLT is not sustainable in law. It's a gross judicial impropriety. If you want, we'll set it aside right now and let the
just one request. Not this current IRP. This current IRP has a lot of complaints.
We further clarify that. If any of the parties have any objection with regard to the conduct of the present RP, is it RP or IRP? IRP, he would be entitled to move an application before the learned NCLT for change of the IRP, which application would be considered.
What has happened is, his conduct extends to this court.
So you pointed out to the NCLT.
No an application.
Mr. Kohli, with such sort of allegations by any of the parties, would it not be appropriate for you to walk out?
Specifically made a submission.
So, can we, if we have your permission, some of the parties have raised serious grievance with regard to the conduct of the IRP.
Disputed with Kohli.
Though Shri Kohli, the learned senior counsel, appearing on behalf of the IRP, disputes the said allegation. But we do not find it necessary to go into the said allegations. The parties which have a grievance with regard to conduct of the IRP would move an application, would be entitled to move an application before the learned NCLT, which application will be decided by the NCLT as expeditiously as possible, and in any case, within a period of 4 weeks from making of such an application. We clarify that we are not expressed, we are not considered the merits of the allegations and the rebuttal thereof, and the learned NCLT would take a decision on the basis of the material placed before it. Mr. Sibal is there.
If that application is decided.
He should not.
You stand, you keep your hands away, Mr.
Yes, yes.
Okay,
From today onward,
They should not dissipate the asset.
Staying him, he must be
The promotion should not dissipate the asset.
Which is passed by this court on chief K order, by this court on such and such, shall continue to operate, which means that the IRP appointed shall also not take any steps till the next.
in fact, we had filed a.
IRP yourself.
Not take steps, he is accountable for the company.
Let the ED has.
There is a contempt, Millard. Contempt had been filed against the IRP, Millard. Yes.
Let us go further. Till the orders are passed by the NCLT, the order of status quo passed by this court dated so and so shall continue to operate.
Yes.
Thank you. No, thank you.
May I take 2 minutes? I'm the appellant in 7.1. But I was the original operational creditor against whom all these allegations of collusion were made. But after the NCLT passed the order of 29th of March 22, I also filed an appeal saying that please expunge these remarks. I've got material to show that these allegations of collusion were not founded. Now, my lord, the NCLAT by the impugned order dismisses my appeal for non-prosecution. So, my lord, now what happens to me? Because I am seriously disputing those.
The 7.1, the order passed by the NCLT, by the NCLAT, dismissing the, you have filed an application.
I filed an appeal 651 of 22 against the order of 29th March of 22 of the NCLT saying, and I also annexed the earlier order of 6 January 21. I said these allegations of collusion are wrong. Please expunge these remarks.
The grievance of the appellant is that the observations made by the NCLT in its order dated to second order.
29th March 22.
29th March, in para 57.
It's the same date, 29th March 22.
29th March 22, with regard to collusion, are unsustainable, and therefore he had filed an appeal for expansion of the said remarks. It is the further grievance that the said appeal has been dismissed without giving an opportunity to the
by way of the impugned order
petitioner to the appellant by way of the impugn order. Paragraph. Anyway, we set aside the order dismissing the appeal. The appeal of the present appellant is restored to the file of the NCLAT, which would be decided in accordance with law after hearing the parties.
Yes.
Everybody will maintain status quo. Mr. Kohli, we are not passing any order. We are not passing any order, but don't do anything for a period of 1 month. And we would expect that
Either is a statement be recorded, Millard, or your lordship should pass the order.
we have a practice of believing in the statement of the conscience.
Lordship, I am grateful for not passing it specific.
You advise your client and we believe in your word. That you will not do anything for a period of
That's why, but Lordship, why are only one sentence? They are, this is Lordship, I must point out, the promoters are dissipating assets, so they must hold their hands.
Millard, in fact, we have to file a contempt against them. Contempt is to be taken.
We have called out item 8. This is coming up for the first time before us. We don't know why it traveled from that court to this court.
Only one thing, Millard, I have filed a contempt. I have filed a contempt because of the action of the RP. Millard.
It will go in accordance with law.
Either the contempt notice be issued and they have to face it, or they should give an undertaking.
The contempt petition is disposed of with liberty to the petitioner.
Okay.
File an appropriate application before the NCLT.
I have also filed a contempt, Lordship, so I'm all
which will be considered in accordance with it.
No, Lordship, I have also, so therefore, in fairness.
You have said that they will decide within 4 weeks.
My lord, in the earlier matter, my lord, in 7.1, against the collusion findings.
I think today must have been a real. Today's day must have been a real Diwali day for the.
Lordship, Diwali and Christmas combined.
The findings of collusion and appeal was filed earlier also, which was withdrawn by the promoters.
Yes. Next matter.
You raised that objection in the NCLAT appeal.
They have already withdrawn, the promoters withdrew.
As per
My
objection.
lord may say all objections will be left. All
You have said that in accordance with law after hearing all the parties.
This status order is not coming that way.
Lordship, I must assess.
Serial number 8, please.
Mr. Sen,
Item 8.
unless all of you.
Yes, serial number 8. Who is in serial number 8?
Grateful, Lord.
Thank you.
Thank you, Lord.
Project ought not be inspected. Kindly appreciate this.
Who is in serial number 8?
8.1, my lord.
Yes. Proceed.
Millard, my submission is this.
I am a peer responder. Across the council for requested for a short adjournment yesterday on the ground of bereavement. However, my lords, we have a request to make, my lords. My lords, exams are appearing, exam is conducting today at 2:30 PM.
You pursue with that NCLT everything we have now.
Because of this Manol 2011 project, Millard.
Mr. Lauti, don't allow yourself to be divided. Otherwise, we will be in this stage for another.
This happens because of the joint venture. The home buyers, some of the home buyers are have formed. Now they're
At least, Mr. Lauti, at least before NCLT, something could be done. If the matter remains pending here for years, nothing will happen here.
We just clarify on this project now that we can pursue those remedies. Against audits.
How will you execute it? When it comes to execution, how will you execute it?
Because of the status quo order,
How will you execute it even if it culminates? Concentrate here and get the some promoter who comes in and gets your project going.
Yeah, that's against audits, not against 3C. Our audits is the project demand. Our only audits will be permitted to pursue our amendments.
Our only
Who is in 8.1?
8.1, my lords, I am.
My lords, I am appearing in item 8, my lords. It's for the applicant's college counsel for the respondent requested for a short adjournment yesterday on the ground of bereavement in her family.
There's an IA.
There's an IM, my lords. I'm appearing in 8.1 for Ms. Ankita Chaudhary, my lords. It's a bereavement in the family. I'm requesting.
I'm just requesting. We have no objection, but we are just requesting, today is the last exam, my lords. If students could permit to write the exam without prejudice to the rights of the parties to contest this IA, my lords, subject to the outcome of this IA.
Next week.
In the Allahabad High Court has now given a judgment upholding the entire this examination and selection. I wish to file that before your lordship. Your lordship will only call next, and has also exonerated us of any charge of conspiracy in the challenge to the examination.
Being led by Ms. Prashad. We also have just received this judgment and we want to produce a copy. So we also seek a short accommodation.
So when do you want? 2 weeks, 3 weeks?
Next
2 weeks, my lord. 2 weeks if it's possible.
I'll file it, my lord, because judgments.
2 weeks, 2 weeks.
May I please, my lordship?
Appeared, your lordship. In the first round, your lordship.
Right, okay.
Here is the order.
I see.
Not to be placed before the bench of which Vishwanathan liaison member.
Is the order? Have you appeared in this very proceeding? Otherwise,
No, yes, it's the
I
same.
can't burden my colleagues recusing.
The first round. He is one of the accused.
Chinnaraj.
Yes, your lordship. Padma.
Here only 2 accused are there,
No,
Sengutuvan
there are
and
six,
Anand.
six. He is one of the accused. Your
Accused are there. Only 2 are before the court.
Yes,
I think.
2 are before the court.
They are all. But I case is same, he says.
Yes, same, your lordship. Indeed, your lordship.
Lordship may give me a date, madam. Item number 10.
We can't give date.
Right, Lord. Right, it was only adjourned, the matter is there, also even lordship appeared, there was only adjourned matter.
What Mr. Lenin says is, in a council, you have fully read the brief, fully absorbed it. I don't want to discharge that presumption, let it be there.
Your lordship, I don't have any objection. I'm ready for argument. Your lordship. Nevertheless.
Same case. No.
Oblige, my lord.
You have presumed something in my favor.
Yes, who is for the?
Mr. Guru Raj, sorry.
Yes.
I've been in incarnation for 9 years, 9 months, and I gave pensioners who dealt in the pendency of the case.
Yes, Mr.
Undergone period is 7 years, my lord, 1 month. Excluding remission, my lord. Including remission.
What are the antecedents?
My lord, apart from this case, my lord, 4 other cases.
I thought you mentioned 8.
He's been acquitted in all the matters. It's this on page filed by my learned friend only.
8 instances, my lord.
Counter there.
8 cases are mentioned in the counter.
But he's been acquitted in all the matters.
All the 8 matters?
No, I think some are pending.
So as per my instructions, I've been informed that.
Ms. Shifali, 1, serial number 1, serial number 6.
It's not
One is
mentioned.
has withdrawn.
I've been informed that
Well,
they
the
checked
status
that
is
he's
not
been
known.
acquitted. The matters have been settled.
Also, 9 years, 6 months. How much now? Total undergone?
7 years, 1 month, my lord.
No, but with remission, I think 9 years.
9 years,
9 months. And other 2 accused have also been granted during the pendency of the appeal.
Most of them he has been acquitted. The petition challenges order passed by the learned division bench of the High Court dated so and so, by which an application for suspension of sentence came to be rejected. Whereas the application, the petition is vehemently opposed by the learned counsel for the state. It is submitted that the petitioner is involved. The petitioner's past record would show that he is involved in various yes.
9 years, 9 months.
The petitioner, actual or with remission?
With remission.
With remission.
The petitioner has been incarcerated for a period of about 9 years, 9 months. Also, taking into consideration that The appeal is of the 2017. There is no possibility of the same being heard in a near future. We are therefore inclined to allow the petition. The impugn order is cautioned set aside. The order of conviction, or the order of sentence is suspended during the pendency of the appeal before the High Court, directed to be released.
My lord, starting with the lighter note, same order, my appeal is pending. I've been in 2 years in jail, 5 years in the sentence, no evidence of the mobile recording found.
11 years old victim, my lord.
But,
No reason to falsely implicate, my lord.
My lord.
164 statement is there.
164 is
Other
statement.
statement is also there, my lord.
Kindly see, my lord. There is, the FSL report even does not suggest that any.
5 years.
5 years, 2 years.
2 years.
2 years
Two
has
years.
undergone.
Carrying fish.
Exactly.
But the girl will have no.
No, you're right, you're right. No.
And her 164 statement is also there.
Mother decided I'm really.
Yeah, evidence is there. PW4, no?
Yes.
PW1 annexed later.
He came.
Page 109. But she vacillates in the initial portion a lot.
Only so far as they're putting the hand in the. Otherwise, rest of the things here, there's just a minor contradiction.
Otherwise, my lord, as per section 11.
Which appeals are being heard in the Delhi High Court?
Honestly speaking, the regular matters are not being taken
Huh?
up. Regular matters are not being taken up from last many years.
Delhi High Court? No regular appeals are taken up.
Very rarely the appeals are. There's only.
If it's a short appeal, it can be directed to be taken.
But then they are not being, then why should he be made to jump with an application for suspension of sentence? The application is vehemently opposed by Raja Thackeray, the learned AG appearing on behalf of the state. He submitted that the petitioner is involved in a heinous offence, and as such, the High Court has rightly rejected the application. Correct. The applicant has been sentenced to suffer a sentence of 5 years. Out of that, he has already undergone almost 2 years. There is no likelihood of the appeal being heard in the near future. We are therefore intend to allow the application. Pehle wala order.
My lord. I know Mr. Raja Thackeray and we both have worked in Bombay High Court together.
You worked in Bombay High Court?
I appear, go and appear Aurangabad, Bombay.
You have never appeared before me.
No.
I've been at all the places, Aurangabad, Nagpur.
Used to appear at Aurangabad.
Nagpur, Mumbai, and even Goa also. Mr. Thackeray used to regularly appear.
Luckily, I got the chance here.
Time for the respondent state, give me 2 weeks time to file my counter affidavit. Now the Lord Sabha please issue notice.
Yes.
Notice was able to file my counter affidavit.
He has undergone the sentence or not, isn't it?
Yes, he is completed, is already in 1 year extra, which was awarded by the.
He wants a government job.
Revealed by the.
Yeah, 302 is converted to part 1.
304 part 1.
Moving forward.
Criminal matters, what is the necessity of finding counters? We don't know. We have to decide as per the record, as per the evidence. Unless it has something to do with material aspects, we don't. In High Courts, we never file up replies in the criminal appeals. The matter has to be decided on the basis of the record of the trial court.
Coming after notice, my lord.
This matter offers to suggest, my lord, that service was effective to respond to accused, but he has refused it, my lord. So, my lord can keep any day for my argument. Can keep any day for my argument.
Jobbins,
State your lordship.
and who is for the complainant?
My lord, I am for the complainant, my lord, petitioner complainant.
Yes, you are against,
My lord,
against grant of question.
R2.
My lord, office report say that he refused, my lord, service. It was effective from the registry, he refused. That came in the office report. Or if they can be, my lord, he can be served through a state, my lord.
So the office report shows that the respondent number 2 has refused to accept the service. Also, in order to give one more opportunity to the respondent number 2, issue fresh notice returnable office. We direct the respondent number state to serve the said respondent through concerned police station.
Lordship.
My lords, I'm appealing for the state of UP. My lords, I'm seeking 1 week time to file my petition.
Yes, obviously, Haryana will look after.
If I may, lordship, just seek the indulgence.
And my lords, this corner number 1 is unserved. Union is unserved in this matter, although not a relevant party.
Which one?
Item 15, my lords.
15, I think.
Union respondent number 1 is unserved in this matter, although
It's a formal party, yes.
Yes, ma'am.
And who is appearing for the state of Uttar Pradesh and state of Haryana?
My lords, I'm for the state of UP.
UP.
Yes, Lord.
You are ready with the matter?
I'm seeking a week's time to file.
2 weeks.
If I may just, lordship, seek permission to mention 19. Lordship, 19 had come up before lordship on 11th. It's been listed on 17th of December. The learned senior
Yesterday
counsel.
somebody mentioned.
Yes. But it's come up in the list today again. It's actually, next date is 19.
This is that demonetization.
Yes, lordship.
Somebody mentioned
Jerry
it.
Gupta's son is, I think.
It is admitted, but it will have to go in January now.
Lordship has fixed 17 December. If lordship would be so pleased to.
We are not aware about the change of the roster system.
I understand lordship, but since lordship already passed an order, I thought if I may pursue it and request lordship to keep it on 15 December.
Mr. Athres, where were you in the morning yesterday? Nobody appeared for.
In item 4, my name is not there, but give me 2 weeks time, I will take instructions, I will finalize.
I'm so great.
In item 4. Oblige.
Deeply obliged, lorships.
Well, your lordship may have the order which your lordship passed on 11th of November in this.
May you kindly see the chart I have prepared for each and every matter. There is 27 matters, my lord. Out of 27, in 9, 2 matters are different, my lord. 25 matters are belong to the estate of UP, my lord.
25 matters belong to?
State of UP. And out of 25, my lord, in 16 matter inspection has been done and either deficiency has been communicated to the college or final decision made. In 9 matters, my lord, they did not permit the inspector to enter in the premises. That is there, item 36, 36.2, sorry, 36.2, 36.5, 36.6, 36.9, 36.10, 36.17, 18.
Would yours say inspection arranged but not yet conducted?
Yes, because they did not permit the inspector to enter. In the premise that they have filed the application. I have no objection, my lord, is my lord's permit us to inspect the college and grant the approval as per the.
Why you did not permit them?
About the very prayer thought in these applications is that we were granted approval at a stage where, my lords, we could not even get affiliation and we could not admit any students. So the approval granted in the previous year be considered as approval for this year. And my lords, in 23, your lordship passed so many orders. I have brought those orders. Where approval was granted at the very last stage and no affiliation and no admission. So your lordship in February, March, April, May, my lords, in several cases directed, my lords, that approval granted in 22 should be considered for 23-24. Likewise, on 23rd September, the order that has been passed by your lordship in one case, that was a case where approval was granted on 30th November 2023, which was the last date fixed by your lordship on their application. Now, when approval is granted on 30th November 2023, and it takes about 3-4 weeks time to obtain affiliation from the affiliating court, by the time that affiliation, the last date for admission is over. So it was a 0 year. That is, in those circumstances, on 23rd September, your lordship directed that this approval for 23-24 be considered for 24-25. They have, my lords, complied with that order recently and granted to that institution approval for 24-25 without inspection. The whole case is that why inspection where the things are moving since 2022, your lordship has dealt with that moratorium matter. Since 22, none of the institutions are able to take part in counseling as far as UP is concerned. In all the states, though your lordship is fixed 30th November as the last date for grant of approval. In Madhya Pradesh, counseling is almost over. Maharashtra counseling 2 rounds are over. Because of this legislative or assembly election, the state authorities have put the 3rd round on hold. Haryana, the counseling is over. Everywhere, counseling is over. Now, this kind of, my lords, seeking extension of date for
Applications are rejected.
Lords,
36, 36.1, 36.2.
then, my lords, your lordship may make alternative submission.
That we had been telling you from the other day also. If you are averse to inspection, then we will not consider it.
Your lordship, no, we were trying to point out that why
Reject it. Yes.
the alternative lords may have request for it.
If somebody is averse to inspection, why should we entertain?
Your lordship, I'll make an alternative submission. Since some of the institutions, as my learned friend is pointing out, since the matters were filed, they may have refused. Your lordship,
Why should they refuse an inspection?
Your lordship,
Filing our petition is not a license to.
since your lordship had passed an order on 23rd September, so it was felt that maybe same order is passed. But now, since your lordship has extended the time till 25th and final date 10 December. So your lordship may say in these cases, the inspection will take place within this much time and will cooperate.
He said it in the beginning itself, but you were averse to that.
Your lordship.
Now we won't grant that.
Please kindly consider that.
No, you have to be fair, Mr. Sharawat. When fair the suggestion is coming.
Only, I was just trying to point out that this was happening every year and
Therefore, we should grant you permission without inspection.
So yeah, your lordship may kindly consider fixing some time only in these matters and your lordship will allow that.
Which are those matters?
In all other matters except 9 matters, my lord. Item 36.3, my lord, inspection has been done, deficiency has been communicated. 36.4, my lord, inspection report received, my lord. 36.5, refused the inspection. 36.6, my lord, refused the inspection. 36.7, compliance has not received, my lord, deficiency has been communicated, my lord. 36.8, my lord, report received, my lord, decision is pending, my lord. 36.11, 36.12, 36.14, 15, 16, 19, 21, 23 different blocks, 23, 24, 25.
I believe in these matters, inspection has already taken place.
Yes, so they will consider it, yes, and pass approval.
That your losses may dispose of bloods, or order your losses are pending for that. And they will also inspect bloods wherever they want to inspect or bloods. We are absolutely not averse. I prepared a chart bloods along with my other friend. I think most of the cases they have carried out inspection, and again this year also they have carried out inspection. And we are willing bloods, they want to carry out bloods throughout the year, they can bloods, there is no difficulty. If I may pass on. Your office may dispose of judging bloods, carry out inspection whenever they want.
Very common orders.
Very good. Your office will have.
You are covered in this 36 order. You are covered, no? Very good.
The order I have annexed at page 2 of this. But if this chart your losses will have, plus I have also annexed the order that you also have, and plus I have given one approval letter at the last page 4. Page 4 is the approval letter which they have given, that throughout the year they want to carry out surprise inspection also. Your losses may also observe the inform it's better to have surprise inspection also. We are willing to have that. That's no difficulty at all.
Lord, inspection is due only in 9 cases.
The order is at page 2, which
The Learned Council for the Pharmacy Council has given a list of the matters and their present status. It is submitted that in how many matters inspection is carried out?
In 16 minutes.
In 16 matters, the inspection is already carried out and the inspection report is conveyed to the institute's concerned. He however submits that in the 7 matters, the 7 or 9?
In 9.
In 9 matters, the inspection could not be conducted since there was resistance from the institutions. Paragraph. Shri Sherawat, the Learned Council appearing for the applicants in some of the matters, some of such matters, states that since the court has passed a similar order on 23rd of September 2024, the applicants did not find it necessary to undergo inspection in as much as they were under an impression that in view of the orders passed by this court dated 23rd September 2024, they would get automatic approval. Paragraph. Shri Amitesh Kumar, appearing in some other matters, fairly states that he is not averse to inspection. On the contrary, he states that the surprise inspection could be carried out throughout the year so as to ensure that institutions are being run in a proper manner. Paragraph. We dispose of all these applications with a direction to decide the cases where an inspection is already granted prior to cut-off date so that the institutions can avail of an appellate remedy. Paragraph. Insofar as the inspections in institutes where inspection is not carried, so we direct the pharmacy council to conduct an investigation and
Inspection.
conduct the inspection and take a decision before the cutoff date. Also, if any of the institutions resist to inspection, it will not be necessary for the pharmacy council to consider such application. Paragraph D. MS and disposal the opposite.
There are also 15 MA which could be listed. In all these cases, inspection has been done, they have pointed out deficiency, you are not laying forward with me.
But I'm giving a list, so all these MAs can be disposed of in terms of the sale.
36.22 is definitely similar to 77, where my word taken and given for his normal. Mr. Pandey is not done this. This is, if the petition is not submitted this year, also they came process, due to.
No, we had passed an order in the particular faction, so we won't go on passing the orders in the last date.
With permission, my lords.
It will be opening a Pandora's box now. Yes, thank you.
With permission, my lords, item 36.13, my lords. My lords, what is happening, my lords? One of the inspectors are refusing for the inspections. There, the case is not that institution is refusing for the inspection. No, my lords, at least there should be some.
Yes.
My lords, the case is that one of the inspectors are refusing. They are not able to come for the inspections. In these cases, they should take some measures, my lord, because in many of the cases there are 3 inspectors. 2 inspectors are ready for inspection. One inspector refused at the last moment that he is unavailable.
They will ensure that the inspection is conducted.
Because that item is also covered, your lordships have passed the direction, they will inspect. So that will be taken care of.
Oblige, my lords.
I will apply next year, but then consider this AOC for next year.
We don't want to pass order again. Mr. Sherawat will come in the next year. And I've been granted permission for 23-24, so no inspection this year. No.
My appearance will mark.
Yes.
My name is not showing the permission. Apply.
Bold में mark कर लेना.
Please grateful.
Deeply obliged. Deeply obliged.
My lordship, I am appearing for the respondent, my lordship, seeking time to file the counter, my lordship.
Yes.
We have to file counter in this case, my lordship, so seeking time to file counter.
All the 3 observations made by the High Court.
Mr. Shiva Prakash, Gita makes the demand, Sudha Gita. You just show something.
But actually, it's completely bereft of use the word perverse finding, but we dismiss the perverse finding.
No, there are other cases which have been quashed, but this case, when you see, so demand by him.
Demand is, there is a telephonic conversation, page 76 of the complaint. The specific demand by him, you bring 10,000 now, then your file will be moved, thereafter another 10,000.
No,
Sudha says you have to pay 20,000 rupees, but he breaks it up to 10,000 and 10,000. He breaks up the demand. And he specifically says, I also took the Kannada document, I'm not being able to annex the.
Trap party also goes only to Sudha's house.
From Sudha's house, they go to CDPO's house. In CDPO's table, 20,000 rupees is kept.
Who keeps? Sudha keeps. Well, where is the demand by Shiva Prakash?
He's already demanded months. He has demanded 10,000 rupees telephonic conversation. You also kind of pay 76. What happened now? The High Court covers scenario where the stage they're watching. They don't even allow it to go to the investigation stage. So I think FIR stage quashed.
When?
2 weeks, maybe.
2 weeks to file counter. 2 weeks to file counter. In the event the petitioners desire to file any rejoinder, the same shall be done 2 weeks thereafter, whatever up to 4 weeks.
Please, Your Lordship, I'm appearing for the respondent state. Your Lordship, I'm seeking 4 weeks time to file counter.
We inform the petitioner's father that the petitioner's father on 27th. We would like to place that back on the. If the Lordship may allow if the matter to be listed anytime before
20?
Lordship, we need 4 weeks time. We need to seek instructions from the department.
Oh, we don't understand what instructions you require in such matters.
It's coming up for the first time after notice, Your Lordship.
So first time is an adjournment time. But next week रखना 27th के पहले.
It is not. The various provisions of the Cinematograph Act and rules and guidelines. I have one request. The record is quite voluminous. Readings are complete. I was only requesting your Lordship's.
Well, why should all such petitions be filed directly before the Supreme Court?
Today, your Lordships have the pleadings have been completed today, my lord. It raises, my lord, the issue, my lord, of the judgment in Abbas, my lord, not considering your Lordship's earlier judgment in Bridgebush. And we made out a case of discrimination, specifically queer documentary films. When the certification of documentary films, my lord, it is our respectful submission that documentaries do not fall within the definition of cinematograph, my lord, as defined under the Act. The provisions, my lord, provided for constitution of the board and the advisory committee. I'm sorry. Therefore, my lord, it was, I'm being led by Mr. Datta. So that was our submission, my lord, that the constitution of the board, as also, my lord, the advisory committees under the Act required consideration because there are no qualifications prescribed, my lord, as to who should be the chairperson. There are 25 members, my lord. What sort of qualifications these members should possess? Their experience, my lord, in the field of, my lord, certification of films and such, my lord, other forms of audiovisual, my lord, demonstration. Therefore, my lord, we are only requesting if the Lordships could give us, my lord, one opportunity. We place on record a short written synopsis, my lord. Only assist your Lordships, my lord.
Yes. Entirely cease pre-censorship in films also.
Yes. And therefore, my lord, although there is now an enactment that the Union government has, my lord, notified on the 5th of August, my lord, 2023, that, my lord, does not address the concerns raised by us in the writ petition. It makes very minor modifications to the provisions under the Act. It provides for, my lord, certain classifications for age-based classifications for certification, etc., my lord. But insofar as the provisions that we have put in issue, my lord, the amendment does not deal with, my lord, any of those challenges. So, Lordships could kindly have this in January, my lord. We'll put in a no.
Why should we enter?
Connected matter, my lord.
This is like saying 19(2) restriction also should not be seen.
My lord, that's not what we are saying, my lord. We are not saying that, my lord. In fact, we are asking for, my lord, if your Lordship sees, one of our prayers is that the government should frame, my lord, if your Lordship sees, my lord, one prayer specifically to answer that query, my lord. The Lordship sees page 77.
Yes.
I'm sorry, my lord, page 78, Roman 10, my lord. Because we are focusing essentially, my lord, on documentary films, my lord.
So you are in the prayer.
Yes, my lord. I'm sorry. Prayer at page 78, paragraph 10.
Oh, first matter, hard copy then. First matter is not uploaded.
Yes, one, sir. Please. I'm sorry.
Yes.
Lordship sees, note prayer 9 and prayer 10 at page 78. Reading down of provisions of the Act so as to exclude from its purview documentary films and declaring documentary films do not fall within the ambit of section 2C, read with 2D of the Cinematograph Act and consequently not subject to pre-censorship norms. Then please see 10, my lord.
Directing the central government to frame appropriate rules so as to incorporate provisions of disclaimer, text, appearance, length, etc. that should appear before the beginning of documentary films, and to that extent alter the provisions of the Act. So, my lord, we are today saying, my lord, that as far as, my lord, the concept of a cinematograph itself is concerned, a documentary may not fall within the definition of Cinematograph Act as defined under the Act, my lord. Pre-censorship of such films, my lord, certainly is something, my lord, that the court will look at, my lord.
Aram Seshadri and all issues.
Yes, my lord. And my lord, Bridgebhushan specifically dealt with this issue. Abbas, K. Abbas, my lord, with utmost respect, my lord, has completely, my lord, overlooked the judgment in Bridgebhushan.
Hidayatullah.
Yes.
So when do you want?
In January, if your lordships could be.
I would also, as an officer of the court, it would be better if your lordships have the advantage of a high court determination on all of these exhaustive prayers. There are developments that have happened. I don't know if they want to amend their prayers also.
I don't, because the Act does not amend it.
Because now notification does include some regulation for OTT, pre-censorship, etc.
Correct, but doesn't deal with documentaries, not our principal
It's a
concern.
developing field. If you're lucky from here, can't say, man.
7 years.
And pleadings are complete.
And to start with, you may have judgments unless they establish that it is
My matter is also related to this. In this, there is a more fundamental issue of what constitutes as far as they are concerned public speaking. What is the public speaking? So you can define arbitrarily what has to be censored, what doesn't have to be. As this, they want to answer my. They have not said an answer to that for 7 years.
Which is the other petition?
Plus 18 months. Mr. Pankaj Butalia, something to that.
ठीक है जनवरी में जाना.
First week we say.
If they don't want to, we can't compel them to file response.
I will examine it, my lords. I was not aware that the secondary petition has separate issues. I'll examine it, and if required, we'll answer.
In fact, there was a small issue also of amendment. We want to add one particular clause, an issue which pertains to a clause 6 in the Act, which gives the federal government overarching powers to overlook anything that the census board has done, and the certification board has done. So we wanted to amend the to be able to put that in also. That was a very matter also.
You want to amend the petition?
So when we should put in this clause, this is put in 3 years ago, 2 years ago. It's not come up with this, so unfortunately. It's still pending.
So you want to amend the petition or?
It's filed an application. I filed an application for that.
You already filed an application.
Already filed an application 2 years ago.
You are suggesting self-regulation.
No, I was more suggesting that if the censor board has made a decision with the certification board, the central government shouldn't have an overarching power as under clause 6 of the Cinematograph Act. It says it can on its own for whatever is given. Overlook at the decision. I can take it.
We'll allow that so that you can respond to this also.
We don't have the application, but we'll answer, my lords.
Just it's only one ground. It's an important ground. We want to give it independence. You are a regulator.
Please, my lords.
Application for amendment is allowed. The amendment will be carried out in a period of 1 week from today.
Their prayers may be at variance with each other. One is saying don't do, and this. We'll see, my lords.
That is it's not what control. The kind of we as control.
Yes.
We are the elected government. We have to have control.
I'm talking about the board. What to do.
We'll answer, my lords.
I explained to the board not before you were not aware of. I explained to them. I read 3% base document. I'm a filmmaker of 25 years of standing. I've been waiting for 7 years to come up. I'm 75 years. 1/10 of my life is gone in waiting for a hearing for this case. I like to.
Coming up before us for the first time.
And we are ready. They wanted time to put together a compilation.
My time is time.
As far as we are concerned, we are not adjourned it even on the single occasion. It's coming up for the first time today. It has traveled from the other court to this court.
Yes.
We don't know the present, what will be the system in January, because this present system will go on till December end. So,
After January.
after January only.
After January.
You are going for shooting some documentary.
I'm going to my family for my.
We wish you happy birthday in advance. Yes, we always. Yes. Extend the case law. And then in case we can prepare a joint compilation of the case laws rather than.
Abbas is how many judges?
5.
We'll have to share it briefly.
Mention it in January.
Very well. Yes.
An interesting passage that as it is wrongly said of a Frenchman, Abbas.
As item 20, the prayer was for accessibility guidelines, Manoj. We've actually complied with it. Your Lordship's wide order dated 7th February 22, my lords, had directed us to find a solution. Actually, I'm sorry, 12th November 21, my lords had directed us to find a solution, my lords. And my lords, we have now placed, if your lordships will have our affidavit. Well, at 17/9/2024, affidavit, if your lordships will see, permit me to just place some orders first, my lords. Kindly have. Order dated 12th November 21, my lords, may I have the order sheet for a moment, my lords. 12th November 21, my lords. So my lords noted that that department is not treating it as adversarial. Then my lords permitted us that we will constitute an expert committee of concerned department. We'll be able to find out solutions to the issues raised by the petitioner, and to the extent doable, solutions will be implemented in right earnest. And if certain issues require some time for implementation, that would be presented before the court on the next date of hearing, including issues which cannot be taken forward at all. Well, the issue was for guidelines for accessibility, Malats. Digital education guidelines. I'll just show, may I just place prayers?
November, the Chief Justice made an order, isn't it, in one matter?
My lord, grateful. Rajiv Raturi, I'm carrying copies of the judgment. My learned friend would hand it over. My lord, that's a very, very important point, because there has to be, firstly, the nomenclature is problematic. When we call them guidelines, it gives a notion as if it's just setting up some sort of standard which may or may not be complied with. It really doesn't give that notion of it being mandatory. Also, because then those, if we call it rules, those rules would then also have to lay down what would be the consequences if it's not being followed. And in fact, the Rights of Persons with Disabilities Act itself provides for the consequences. In fact, our prayer also said so, that there has to be a timeline within which, if the institutions fail to comply with it, then consequences ought to follow. So if my lord has the judgment.
Yes.
My lord
Place
may
the
come
conclusion. Conclusion
My
part.
lord may come to page 43 for a moment. Para 67. The minor note to Rule 15 states that it contains rules for accessibility. Para 68, a perusal of the standards for accessibility laid down in clauses so and so, in the form of the guidelines issued by the concerned ministries, indicates that most of these documents do not contain mandatory or non-negotiable prescriptions. the use of the term guidelines rather than rules in most of these documents is not a mere difference in nomenclature, but is evident in the content of these documents as well. To better appreciate it, and then gives example from that, HG 2021, and then, my lord, so therefore, there has been an emphasis on the guidelines to be framed in such terms so that it's not understood as non-negotiable. Now, if my lord may come to, so para 71 again at the end. If my lord may come to Rights of Persons with Disabilities Act for a moment, because these sections are being referred to, it's important to have a look at section 40, for example. Section 40 of RPWD Act 2016 would say accessibility. The central government shall, in consultation with the Chief Commissioner, formulate rules for persons with disabilities, laying down the standards of accessibility for the physical environment, etc., including appropriate technologies and systems and other facilities and services provided to the public in urban and rural areas. Section 44, mandatory observance of accessibility norms. No establishment shall be granted permission to build any structure. So something of this sort, unless that is provided in these rules, my lord, our experience shows that they are not being complied with. Now, these UGC guidelines have still been notified under section 40. But other than that, rest of the guidelines have not even been notified. Section 46, my lord, is important. Time limit for accessibility by service providers. The service providers, whether government or private, shall provide services in accordance with the rules on accessibility formulated by the central government and under section 40 within a period of 2 years from the date of notification of such rules. Now, my lord, section 89 again is important, which talks about punishment for contravention of provisions of act or rules or regulations made thereunder. Any person who contravenes any of the provisions of this act or of any rule made thereunder shall for first contravention be punishable with fine which may extend to 10,000 rupees, and for any subsequent contravention with fine which shall not be less than 50,000 rupees but which may extend to 5 lakh rupees. So, my lord, unless there is a monitoring system as well as an implementation mechanism provided in these rules itself, it becomes difficult to see them being implemented. Now, my lord, in June 2024, a certain accessibility code for education institutions was notified by Department of School Education and Literacy, Ministry of Education. But so far as higher education institutions are concerned, my petition concerned with higher education institutions, colleges and universities, where a lot many courses are still being offered online. And now with pollution, etc. So online courses has not become redundant at all. And therefore it's important to have a kind of mechanism so that people can be held to account and so that it can be properly implemented.
Have you gone through the affidavit?
Yes, ma'am.
This judgment, I've just seen the conclusions, but if your lordships will see the prayers of my learned colleague, her prayers were limited, page 19 of the writ petition. And in this petition, we have gone through the entire exercise, we framed a committee, we were directed to include them in the consultation process, take their representations, have them personally present. And after that, madam, these guidelines.
I'm very grateful for that. I was on oxygen support when I filed this petition. So to see this outcome coming out of this is very heartening for me personally. Prayer B is important, my lord, because I did refer to, because I was concerned with whether it would get implemented properly or not. And therefore, prayer B, my lord, at page 19, issue a writ in the nature of mandamus or any other appropriate writ directing respond number 1 and 2 to ensure that the said guidelines are strictly implemented within a period of 1 month, failing which a penalty as stipulated under section 89 should be imposed strictly with immediate effect.
No, I think this is 21. See the writ petition 2021.
Fine.
today, you see, after this judgment, Rajiv Rathuri's case,
My lord.
they are obligated to frame certain norms which are non-negotiable.
My
The basic
Great.
ones, you can't call it guideline.
Grateful, extremely grateful.
Chief has, I think, harmonized it with reasonable accommodation. That will be, you know, and certain things can be expansive. He said. So they will have to apply their mind to this.
Obliged, very obliged.
I think it has traveled beyond the prayers in the writ petition.
As I bow down, I've not seen this, the conclusions, because we completed this exercise in terms, and our affidavit was filed in September 24 itself, madam. And we carried out the exercise in this matter. And the guidelines have been framed by UGC, AICTE, NCTE and NCERT.
Mala, these guidelines are very useful,
how
very
much of these
exhaustive.
guidelines-
Please now let her also permit to.
Solicitor is addressing.
How many of these guidelines will, how they will have to be either changed or amended, or how, whether they fall within the parameters, I will have to get instructions, madam. Please, my lords.
We keep it up to 6 weeks.
Please, my lords. Would your lordship consider having this? This is a writ petition of 2005, my lords, Rajiv Rathuri. This, if your lordships are taking compliance of this, it can be taken along with this, then we'll file compliance. I'm sure union is a party here, my lords.
It's better if this is kept separate.
As my colleague likes, my lords, this is non-adversarial, but I'll have to come back now.
I'm really grateful to the learned DSG for keeping it non-adversarial and for making all these efforts, which made it possible. But it's just a little bit that's left to be done in this. Most of it has already been done.
The issues involved in the present writ petition overlap with the issues in writ petition number 6C of 243 and 243 of 2005, in which detailed directions have been issued by this court, white order dated 8th of November 2024. It will therefore be appropriate that both these matters are heard together and considered simultaneously.
I'm grateful.
The registry to tag the present matter along with writ petition number so and so. Posted in when January.
This is already listed for reporting compliance on 7th March 25. Your lordships may see para 81, the last para of the judgment.
And post the matter on 7th of March 2025 as directed by judgment and order dated 8th of November 2024 in WP number 243 of 2005.
I'm grateful.
Why should there be duplicity of proceeding? Let everything be heard together.
Obliged. Okay.
Great.
Batch of 10 matters, your lordship. Services complete, pleadings are also complete, your lordship. Except also there are 2 I's that have been moved. One is for vacation of stay and the other one for intervention. In fact, this matter will take time if your lordships say have a special bench at 3:30. Otherwise, we can start off. It'll take time, your lordship, yes, sir. But the issue involved in the matters, in all petitions are, let's say, the same itself.
My lord, there is very little in this matter, my lord. Lord, against an order of inquiry, my lord's writ petition is filed, which is dismissed. And my lord, this is a disciplinary inquiry, my lord, against candidates who are applying for, my lord, this assistant public prosecutor. And my lord's criminal prosecution was launched. My lord, these people forged their mark sheets.
No, that's not an issue.
And
If my learned friend wants to start, I'll then okay.
No, I just want to what the issue is. And my lord's
it's my
forgery,
petition,
my lord's collusion with the director of prosecution. And there is allegation, my lord, even a high court judge's signature was forged, etc. in the criminal matter. Lord, thereafter
that's again accused 1 and 2. I don't
charge sheets are filed, my lord. And my lord, against that, quashing is also dismissed. Now, my lords, based on this, the state started only an inquiry. They challenge this that the Lokayukta has no jurisdiction to start the disciplinary inquiry because under the 7.2, you can have jurisdiction only in respect of public servants. So when we applied as candidates, we were not public servants, and therefore, my lord, the inquiry sought to be scuttled at the threshold. Your lordships have time and again said this is only a initiation of the inquiry. All their defenses are available. Let them participate in the inquiry, my lord. Since 2018, my lord, nothing has moved. 6 years. Not there.
My lord,
High Court, my lord.
I am the petitioner in this matter. Let me start, your lordship, because actually.
Just one more thing. We were the original petitioners in whose petition, my lord, their application for stopping the disciplinary inquiry was rejected, and the High Court said that let the disciplinary inquiry go on. Against that, they file an SLP without impleading us. And they get an ex parte stay order, effectively staying that disciplinary proceedings. So therefore, the only issue before this court is really whether those disciplinary proceedings should be permitted to go on. They are facing criminal prosecution for forgery, manipulation, all kinds of malpractices that they indulged in to get themselves appointed.
That's not the issue. The short issue for consideration is whether, let's say, Lokayukta can initiate proceedings against individuals, let's say, who are not public servants. That's the issue as of now. As far as the criminal proceedings are concerned, that's still pending, your lordships. We're not really disputing on that.
Well, I appear, my lords, in some of the connected matters. Well, I apologize for appearing via BC, my lord. In fact, the criminal proceedings have been allowed to go on. So, my lords, as far as we are concerned, my lords, the short question is, my lords, the disciplinary inquiry has been commenced against people who are not public servants at the time, my lords, these so-called misfeasance took place. The alleged misfeasance is, my lords, examination irregularities and malpractices. My lord, that was, my lords, prior to them becoming public servants. Under the scheme of the Karnataka Lokayukta Act, my lords, any action that is taken by the Lokayukta, suo moto or otherwise, must necessarily have
against the Shokat notice, you go and reply. Go and reply that the proceedings are not tenable.
My lord, which we have done.
Why should the proceedings be nipped in the bud?
Articles of charges have already been framed, your lordships. We've replied an article of
Which we have done. We have done that. And despite that, the government, my lords, has in fact given the green signal for the Lokayukta to proceed. In fact, my lord, this gets worse because, my lords, the Lokayukta, my lords, which is the investigating agency and the prosecuting agency in the criminal proceedings, is the adjudicator as far as the administrative action is concerned. So, my lords, the judge, who is in fact the prosecutor and the investigator in another set of proceedings, is expected to be an impartial judge in the disciplinary inquiry, which can never happen. So these matters, my lords, may require some time, my lords. We are, of course, happy to make a start today.
Lord, in identical matters, my Lord Justice Vishwanathan sitting with Justice Maheshwari, my Lord, pass that order that all your contentions are left open. Kindly have that, just hand it over.
If the lordship is hearing it, my lordship may have this of plain side.
All their contentions regarding disciplinary inquiry, etc.
Let him proceed.
Very well.
In fact, the short issue for consideration is that whether Lokayukta can initiate disciplinary proceedings for acts done by individuals, let's say, much prior to they becoming public servants. In fact, 2012, your lordship, so let's say 197 posts, let's say for the post of assistant public prosecutor and assistant government pleader were called for. The petitioners herein actually appeared for the written exam. They were qualified. They actually participated in the YOC. They were a part of the final select list of 197 candidates. Appointment orders were issued. Post that, in fact, let's say in 2014, your lordships, say ST Ravi, who is an unsuccessful candidate, so he challenges and he challenges, let's say, the appointment of 197, let's say, individuals, of which he makes specific allegations against accused number 1 and 2 and 23 other individuals, your lordships, wherein the present petitioners, none of them have been mentioned. Then thereafter, the trial court actually directs the Karnataka Lokayukta police for say to file a report. FR is filed, charge sheet is filed. Charge sheet is filed against only accused number 1 and 2, your lordships. Now, post that in the supplementary, let's say, charge sheet, let's say the names of 61 individuals are included. That is where the present petitioners come in. Now, against that, your lordships, in fact, the Lokayukta initiates so motu proceedings under section 7.2. My lordships may have section 7.2 as for a moment. 122 of the SLP, Your Lordships. That's the first SLP.
Yes.
But they must be under suspension because of the criminal thing.
They're 2020, Your Lordships. 2020 itself we were suspended. Your Lordships. Now, our difficulty is, okay, the criminal proceedings are pending. In fact, we have not been found guilty, say, neither in the criminal proceedings nor in the disciplinary proceedings. Disciplinary proceedings have been stayed as of now by Your Lordships.
Yes.
My Lordships, may I have page 122, Your Lordships, for a moment? That's the first line itself. That's okay. I've extracted those provisions for there. That's okay. 7(2) of the Lokayukta Act, Your Lordships. In fact, subject to the provisions of the Act, an Lokayukta may investigate any action which is taken by or with the general or specific approval of any, my Lordships may actually underline this, any public servant, not being Chief Minister, Minister, member of the legislature, secretary, or a public servant. Now, my Lordships may actually make a note of, okay, against the public servant. My Lordships may have a look at, okay, the definition of public servant for a moment. Your Lordships will find that at 118, Your Lordships.
One
119. In the middle of the paragraph, Your Lordship, so it's section, 212. A person means, a public servant means a person who is or was at any point Chief Minister, Minister, member of the legislature, government servant, chairman, member of the committee of the board. What is relevant is, okay, these three things which, in fact, these were acts, okay, which are to be alleged at a time of the written examination, where I was not a public servant at that point in time. In fact, the allegations were that, that there were malpractices during, okay, the examination. Initially, the allegations were against only accused number 1 and 2.
No, but whether the allegation is that you are the beneficiary of that malpractices, whether the allegation is that you are beneficiary of those malpractices.
My Lord, that is yet to be proved. In fact, okay, there's nothing that
we are asking you whether the allegation is that. We know that it is yet to be proved. It will be proved only at the end of the department.
Please, Your Lordships. Yes, Your Lordships.
We are talking about what is the allegation.
The allegation is that I was the beneficiary, Your Lordships. Now, in fact, Your Lordships would say now, so much of proceedings have been initiated, say, under section, 7(2) and rule 20. Now, 7(2) defines, okay, that there is a prerequisite requirement for the Lokayukta to initiate proceedings. Prerequisite requirement is that I have to be a public servant. Now, I don't fall under the definition of public servant.
On the date of inquiry, you are a public servant.
On the date of employment, I was, but
inquiry.
And please, Your Lordship, but these were acts that have been alleged against me when I was not a public servant then. The requirement is that I need to be a public servant, okay, for acts done by the public servant. My Lordships may have a Rule 20, Your Lordships. Rule 20, Your Lordships will actually find, say, 125. Now, proceedings were initiated on 7(2) and Rule 20, Your Lordships.
Where is Rule 20? Yes.
At page 125. In fact, the requirement is that the candidate found guilty of impersonation or by submitting, say, fabricated documents or documents which have been tampered with or making statements which are incorrect or false or suppressing the material information or false or suppressing material information or using or attempting to use unfair means in an examination conduct for the purpose of recruitment or otherwise resorting to irregular or improper means which in connection with the recruitment may be in addition to rendering himself for criminal prosecution or disciplinary action. Now, in fact, Your Lordships may...
So who will take disciplinary action against a candidate?
My Lordships,
suppose the candidate is...
It is the government. In fact, it's the recruiting agency. In fact, Lokayukta cannot so motive actually take...
No, suppose is a candidate practicing lawyer applies for public prosecutor.
Please, Your Lordships.
He commits some malpractice. In your case, you are selected.
Please, Your Lordships.
Suppose he is not selected?
My Lordship, in fact, in that case, let's say Lokayukta anyway, since that person is not a public servant, there's no way that actually they can do that. It is the government itself. Government itself is the recruiting.
Who will implement this Rule 20 against the candidate?
It is the government itself.
Criminal prosecution, yes. Disciplinary proceeding for what?
Disciplinary proceedings, in fact, the initiation of the notice is for, let's say, dereliction of duty, Your Lordships.
in addition to rendering himself liable for prosecution
Please, Lord.
and to disciplinary action, be debarred either permanently. Three things can be done.
Please, Lord.
Criminal prosecution, disciplinary proceeding, debarment. Only question is, who is the authority if he is a selected or a purportedly selected candidate?
Please, Lord. Now it is so the government alone could have actually initiated those proceedings here. Okay, it's a summative proceedings that have been initiated by the Lokayukta under 7.2, which has to be against the public servant itself, or an acts done or alleged to be done, okay, by a public servant itself, not by an individual. Lokayukta Act does not apply to private individuals. It has to be a government servant itself. They have to fall under the category of public servant itself. And in fact, my lordships may have now section 8 for a moment, which actually specifically bars. In fact, my lordships will again see page 122 itself. Matters not subject to investigation. My lordships may have section 8A lordships. That if an action relates to any matter specified, in the second schedule. Now, second schedule, your lordships will actually find it on the next page, your lordships. That's at page number 123D. In fact, there's a strict bar as far as the issue relating to appointments cannot be looked into by Lokayukta. The action taken in respect to appointments, removals, or paid discipline, superannuation, or any other matters relating to the conditions of service for public servants, but not including action relating to the claims and pensions. In fact, there's a strict embargo as regards the Lokayukta actually looking into these aspects. As regards section 8A, read with schedule D is concerned, your lordships. My lordships, now just get back to the list of dates, your lordships. In fact, post the initiation of proceedings in 2018, in fact, a reply is sent. Post that the Lokayukta submitted a report to the government. The government, interestingly, in fact, the inquiring agency is the Lokayukta, and actually it actually addresses those matters to be adjudicated by the Lokayukta
the bar would be if already some action is taken in respect of appointment, removals, pay, discipline, superannuation. In that event, in such an action, the Lokayukta would not be permitted to intervene.
Now, what is under dispute is my appointment as a public prosecutor, your lordship. That's the issue as of now. Now, disciplinary
action was taken pursuant to that appointment by some authority.
Interestingly, in fact, the initial complaint was filed against only accused 1 and 2. My name is not mentioned in the FIR, not in the first the charge sheet. Supplementary charge sheet, they include me. Now, against that, those proceedings are still parallelly going on as of now. Against that, the Lokayukta so much to initiate these proceedings. Where one, I'm not a public servant, it couldn't have initiated, and plus there's an embargo as regards appointments are concerned. Now, more interesting is the state government now assigns the work to the investigating agency itself to adjudicate the matter. Now, I primarily agree by these actions of the state itself. And more so, they can't be two parallel proceedings. In fact, my lordships may have section 8.1D, lordships. 8.1B, 122 itself. If a complaint that has or had any remedies by way of an appeal, revision, or any other proceedings before the tribunal or other authority has not been availed by the same. Here, they've already availed, by filing, a private complaint, and those proceedings, are pending as of now. Charge sheet has already been filed. And as your lordships have already
filed in criminal proceedings.
Please, your lordships. Those are still pending as of now. Charge sheet is filed against that. They can't, and in fact, interestingly now with 2 matters pending, I've been placed under suspension. None of them have actually concluded me to be guilty. Out of the 197, initially complaint was filed against the first 2 accused and 23 other individuals, where I actually not even included. Post that, as per the whims and fancies, they give a list of 63, against which so much of proceedings are initiated and I've been placed under suspension. It's been more than 6 years as of now, Lord, 4.5 years.
So for 4.5 years, you are enjoying half of the salary.
In fact,
more than half. It must be now after some period. It must be 60%, 70%.
Well, now I'm more than willing to work. In fact, let's say there can't be greater frustration where, let's say, being qualified and being appointed as of now, but I've been not made to work. Today, let's say all these people are at the prime of their careers as of now. Now, the very stigma itself, and plus, okay, to top it all,
The stigma will come only after you are held guilty in the proceedings.
My lord, sir, we've been suspended as of now. It's been more than 4.5 years.
That is at your behest. Because of your petition, your suspension has continued. Otherwise, by now the inquiry would have been complete.
What stage is the trial?
Please, lordship.
Trial, criminal trial.
Discharge applications also filed, lordships. It's pending hearing.
Discharge application is rejected. That's what was told.
There are 482 by accused number 1 and 2. Rejected. That is as regards accused number 1 and 2, lordships.
Okay, they continue with the trial of 2000?
My lordships, in fact, it's a complaint of 2017, your lordships. Complaint is 14, your lordships. The recruitment, it's a notification of 2012.
I think if we expedite that, finish it in a short time.
My lordships may do that, but allow us to continue as of now. There's no difficulty as far as that is concerned.
Okay, you can do that.
Now, in fact, what's under challenge is, okay, they're actually seeking cancellation for the entire, 197, let's say, candidates itself. If you're found guilty, yes, okay, your lordships may punish us, but not at this stage. They can't be, let's say, a pre-conviction before anything that's there, before the trial itself. Now, what to say, we have a limited grievance is, okay, whether the Lokayukta can initiate a proceeding, let's say, against a public, against an individual for acts done, okay, who's not a public servant itself. And particularly more so in the light of, okay, where, let's say, now the government has actually assigned the work to an investigating agency to adjudicate the matter. They can't be, okay, judge in their own, let's say, case itself. Well, Lordships, we get back to the list of dates as of now. Now, post that, let's say,
against initiation of 20.
2019 post that I approached the tribunal, primarily challenging being agreed by 3 orders, lordships. So one is, okay, by the government recommending, okay, the Lokayukta itself, okay, to adjudicate the matter against article of charges, against which I approached the tribunal. Tribunal actually dismissed my application. Against that, I filed a writ petition. Writ petition was dismissed, where I challenged it before your lordships. Your lordships actually gave me the liberty to actually file a review. Get back to the High Court and file a review. Review was dismissed against which, but liberty is given to challenge both, okay, the order passed in the writ petition and the review, against which, I'm challenging both the orders, lordships. And against that, your lordships are pleased to actually grant stay, as far as the disciplinary proceedings are concerned.
That's 7.
And that's when they're hearing the matter. 7.2 deals with the SOMO. My lordships may have a look at 7.2 itself. In fact, it actually gives, let's say, the 7.2 is the SOMO part of the Lokayukta to initiate proceedings.
What kind of proceedings?
My lordships, again, look at the allegations that are made. My lordships may have what's.
No, is it criminal proceeding or disciplinary proceeding?
It has to be, say, disciplinary proceedings itself. It has to be disciplinary proceedings itself.
Moving on.
But that also is very local.
My lordships may actually have, what's say, page number
Who is
121.
prosecuting the criminal proceeding? Which police?
It's the Lokayukt.
So going by your argument, even prosecution cannot continue because it is charges when they were candidates.
Please, your lordships. They were candidates, they were not public servants at that point in time.
There also you are raising that argument.
No, your lordship. That's an independent thing. Okay, that's under fabrication and all of it. It's not on these charges. Now I'm only aggrieved as far as the present litigation is concerned, as far as the initiation of disciplinary proceedings against me. That I'm not even contesting. I'm not even actually touching those points as of now. Those are independent, but charge sheet has already been filed. Under that's under okay, section 420, 465, 468, 471, read with 34 your lordships. Not for misconduct, your lordships. My lordships, may get back to section 7 itself. 7 to your lordships, that's 122. Subject to the provisions of the Act, Lokayukt may investigate any action taken with the general or specific approval or any public servant.
Of any public servant.
Of any public servant. I am not a public servant.
On the date of action, you are a public servant.
But these are acts which were done much prior in time. What I've been alleged is an act which is much prior to becoming a public servant. My lordships may have the definition of action. Your lordships will find that at 118. Any action. Action means any administrative action taken by way of a decision, recommendation or finding or in any other manner or includes willful failure or omission of any of the expressions relating to an action construed accordingly. It has to be in my official capacity. My lordships may have now the next definition, that's 2.2. Allegation in relation to a public servant includes any affirmation that a public servant has abused his position as a public servant. Now, if you actually were to look into 7.2, read with section 2.1 and 2.2.
This is conduct unbecoming of a public servant. Who are now a public servant.
Please, lordships.
There is a conduct which has come.
See also, such a public servant is guilty of corruption, favoritism, nepotism, or lack of integrity in his capacity as such public servant.
As a public servant, I was not a public servant then. And in fact,
So
I was not
a
guilty of corruption. I've not been held guilty as corruption. In fact,
a lack of integrity
my lordship,
at the time of your appearance in the examination and that misfeasance.
for that I have to be found guilty. I have not been found guilty as of now. No court has actually found me guilty. The threshold is much more higher. Now, as regards a public servant is different to the one that's of a private individual. Now these were acts done as a private individual. None of these acts were in the capacity of a public servant or any administrative action that is there. In fact, reading of section 7.2 read with section 2.1 and 2.2 makes it amply clear that these are all acts which in their official capacity itself. The Lokayukt would have the power to initiate proceedings under 7.2. And more shocking is that where the adjudicating authority itself, the investigating agency itself now is the adjudicating authority. It's against principles of natural justice. And in fact, as regards even section 8 also, that there is a strict embargo as regards if there are any other criminal proceedings under 8B, you can't actually initiate these proceedings.
You got the copy of the act. So
I have
typed copies are dangerous.
My lordships may have a look at this. There's only one copy, lordships. I'll give to you.
There is another copy.
No copies.
The same one.
Yes, that's it.
My lordships have the second copy. Other relevant sections have been marked also. We did them, marked time. Hey, put up this. My lordship might just have a look at 4 sections. That's okay. One is 7.2, read with okay, section 2.2.2, 2.1.2.2. And 8A read with the second schedule, which bars as far as appointments are concerned. Yes, we have to do. Give me another. The last page. I think so. It's already here. It's there in the paper. It is there.
Not complete. Because we just have one pocket.
What is it? Rule 20.
One is not.
Just flag it up. Hmm? Just flag it up.
So, if you not, if it is not selected, I will, complete.
Now, one more answer to Justice Vishwanathan's query as to say who would be authority if the candidate is not selected. In fact, now proceedings have been initiated under section 7.2 and rule 20. My lordships may have a look at rule 20, which says that it's the government.
If the candidate is not selected.
If the candidate is not selected, then it would be the
The
government.
proceedings are not under the Lokayukta Act. The proceedings are under Rule 14A of the Karnataka Civil Services Rules. Learned friend should address that, my lord. The order which is challenged is under Rule 14A. That order, my lord, lordships will find at page 167 of the SLP paper book. 16 at page, my lord, order starts at 172 at page 176. This is the order of the state government referring the matter to Lokayukta for an inquiry, for a disciplinary inquiry. This is challenged. Kindly have a look at 176 with reference to the preamble and report submitted by the Upalokayukta under 12.3. It is hereby accepted. So the government, my lord, looking at the nature of allegations, applying its mind, then passes this order. It is hereby accepted in order to initiate disciplinary proceedings under 14A. Now 14A merely says, my lord, that the Lokayukta will be an inquiry officer. He will inquire, submit the report to the state government, and the state government will then proceed to take action in accordance with Rule 11A. Yes, my lord. Yes, ma'am.
To be traced to a provision in the Lokayukta Act.
That is under Rule 14A, my lord.
No,
It is started under 7.2.
two capital A, the non-obstante clause in 7. Come to 7.2A.
But 7.2 is the preliminary inquiry.
2A.
Yes. Yes.
Notwithstanding anything contained in subsection 1
Anything
and
contained in subsection 1 and subsection 2.
Lokayukta or Upalok.
Lokayukta may investigate any action
taken by or with the general or specific approval of a public servant. That is,
if it is
he
referred
says, suppose he has
2-1.
given an opinion to close a criminal case,
Yes.
taken in his capacity as an APP,
Yes, bro.
not, something which happened before. That may be subject matter of an inquiry under the disciplinary rules.
That is all, madam. That is what we are saying, madam.
No, he's saying, why are you bringing in the Lokayukta?
No, 14A says so. Kindly have a look at that rule 14A has not been played. There is no other procedure. Kindly have rule 14A.
14A is where?
But the entire
Civil service
proceedings.
So you are saying
terminate out
Lokayukta
the
is only a delegate of an inquiry officer.
Yes, my lord. Now kindly see this. The rule procedure in this case is entrusted to the Lokayukta. The provisions of sub-rule 2 shall, notwithstanding anything contained in rule 9, 11A and 13, be applicable for the purpose of proceeding against government servants whose alleged misconduct has been investigated into the Lokayukta or an Upalokayukta, either under the provisions of the Lokayukta Act or on a reference from the government, or where alleged offences against them punishable under the PC Act or the 1988 Act have been investigated. So, my lord, 4 or 5, my lord's conditions. One, my lord, that there is already an investigation by the Lokayukta, Upalokayukta, or there is a criminal case against them. Then what happens, my lord? The Lokayukta or Upalokayukta, the IGP, the disciplinary proceedings shall be taken. He shall forward the record of the investigation along with the recommendation of the government. And the government, after examining such record, may either direct an inquiry.
See the answer, where they are already being.
How would that apply, your lordship? It's against whom? AB.
1 second. Then just one more provision. After the inquiry, the Lokayukta conducts an inquiry. Report is then submitted back to the government.
The government, the final decision is taken by the government.
Only as a delegate, like any inquiry officer is a delegate. So,
where did the very genesis of the issue start off?
because Lokayukta has already initiated proceedings for those kind of categories which come under 1. For 2, they say Lokayukta will do it, so they will be in possession of all the material, and then it will come as for action taken. Then the normal disciplinary route will follow. They may agree, disagree, notice, differing, everything will happen.
The genesis itself actually starts with the suo motu proceedings under 7.2 itself. Now, the very genesis itself is wrong. Our primary line of argument is that, your lordship. In fact, it cannot be, it has to be against the public servant itself. If a complaint.
See, here Lokayukta is brought in as anybody can be inquiry officer. Here Lokayukta has been designated as the inquiry officer. Receive the report.
I am not disputing that. I am not for a moment disputing any of those powers. In fact, they've already filed charge sheet as far as the other proceedings are concerned.
Thank you, Mr. Dismissed.
Well, could I just make 2 submissions, my lord, because I appear, my lords, in 3 of these matters.
Yes.
My lord, the simple issue, my lords, is we say that there is no jurisdictional fact for a disciplinary inquiry to be commenced. My lords, the jurisdictional fact must be an administrative action. My lord, there is no administrative action, my lords, which has been alleged against me, my lords, for the act of misfeasance. The act of misfeasance that is alleged against me is an act, my lords, that is alleged to have taken place before I entered public service. Of course, there is no difficulty. That can be the subject.
Mr. Mulya has already argued.
My lord, could I just show, my lords, 2, my lord.
Pramod, you are otherwise right, but for 14A,
yes,
which for certain categories of matters already investigated by the Lokayukta, including in a criminal case,
yes,
Lokayukta is designated as the inquiring authority
Yes.
for bringing some kind of uniformity to the extent of inquiry, then the
Yes.
report comes and the normal track follows. To that extent, there is a jurisdictional fact.
I'm so grateful, Manoj. Could I just point out, Manoj, how, Manoj, we would be prejudiced by it? The Lokayukta is the investigating authority and the prosecuting authority as far as the criminal investigation is concerned. Manoj, and if they, Manoj, are put in charge of the inquiry, which they have been by virtue of page 173, Manoj, what kind of justice can I expect? Because, Manoj, the adjudicator is in fact the investigator and the prosecutor as far as the criminal proceedings are concerned. Would it not benefit them for them, Manoj, to reach the conclusion that I have in fact, Manoj, committed a misconduct? But Manoj, that is, Manoj, going much further. The issue is
apprehending too many things.
Manoj, could I just 2 points which I want to make, Manoj. The fact is, Manoj, could I just very, very quickly, Manoj, take Manoj to the genesis of this. The genesis of this, Manoj, is a report by the Upalokayukta under section 7.3. Section 7.3 necessarily must be in respect of an administrative action. Manoj, could I just make that point? Manoj, that section 7 is extracted at page 21. Manoj, 7.2, which your lordships have seen, is the Upalokayukta may investigate any action which is taken by a public servant. The action, Malad, is defined in section 2, Malad, as, Malad, that is at page 118, means an administrative action.
That has also been shown to us by Mr. Nalli.
Yes, Malad, the action must necessarily be an administrative action. Malad, there is no administrative action of which, Malad, I have been accused of any kind of misfeasance. Kindly see page 118. Administrative action taken by way of decision, recommendation, or finding, or in any other manner, and includes willful failure. So, Malad, as your lordships have kindly put it to my learned colleague, but if, for example, they have taken a wrong decision to close a prosecution, or if there is an act of bribery, or any of those aspects, Malad, those necessarily relate to administrative actions. If, my lords, there is any administrative action in respect of which I have committed a misfeasance, of course, there can be an inquiry under section 7. But Manoj, Rule 20, so Manoj, the issue is this. Rule 20 is not a charging section in that sense because it does not create an offense. What it does is it prescribes the consequences of me being held guilty in a criminal proceeding. But then what it does is it permits that there can be multiple consequences that can be visited upon me. I can be held guilty in a criminal prosecution. If I'm held guilty, then I can lose my job. I can be debarred from appearing again in a public examination. Those are the consequences. Rule 20 does not create an offense. It does not prescribe any kind of misconduct for which I can, any kind of departmental inquiry can be commenced against me. So Rule 20 does not apply. Section 7 does not apply because Section 7 again relates to an administrative action. But then in respect of what is the charge against me? The first charge that was made against me, Manoj, was dereliction of duty. Manoj, dereliction of duty presupposes that, Manoj, I have taken an action or I've been guilty of inaction whilst I was a public servant. But an act which...
He also is for one of the petitioners, Your Lordship.
No, you are for which?
Manoj, I appear, Manoj, in 3 of these matters, 21.6, 21.7 and 21.9.
For the selected candidates or for the...
selected candidates, Manoj, selected candidates, selected candidates. So, Manoj, of course, Manoj, there is a criminal proceeding against me. If I'm held guilty, Manoj, Rule 20 will apply with all force. So in addition to me being held criminally guilty, Manoj, I will lose my job. I will be debarred from public employment again. There is no difficulty about that. Manoj, that, of course, the government is entitled to do. But today, to commence a disciplinary inquiry premised on Manoj's administrative misfeasance, when I was not even an administrator, I was not a public servant.
Thank you.
If I may.
Thank you. Thank you.
One request, Lordships, at least till the disciplinary proceedings are going on, some empathy from this court to say, let us at least continue. Anyways, okay, they're paying us 50% of the salary. Until such time.
Empathy.
Empathy.
Well, Lordships, now see, I've not been held guilty as of now. If I'm found guilty, yes, okay, suspension would be right. But as of now, at this point in time, say at least okay, now neither okay, now there are two proceedings that are running against me. Charge sheet is filed in the other case. As far as the disciplinary proceedings are concerned, let it continue. There's no issue with that.
For the last so many years, you are getting so much amount without doing any work, and you want it to be continued.
Only 20. I've served your lordships. In fact, let's say the appointment is of 2014. Post that we've been working. It's only in 2020. It's only in 2020 we were suspended, your lordships. There's one order of the High Court itself which says that, in fact, which is also challenged by the state, which one SLP which is filed by the state, where High Court specifically says that until such thing, until the proceedings are on, they take the services.
Where is that appeal?
Malachus may have a look at that order.
Grateful.
Option or direction to take the services?
It says, my lord, in that view of the matter, we direct the first respondent to consider revocation of the suspension order and pass appropriate orders within 15 days from the receipt of the copy of the order. And also, and says that the services of the petitioners may be utilized to the respondents, or otherwise the fact remains that the subsistence allowance paid to the government servants would remain unpaid. Page 5.
Page 4.
So what have you done?
They have not taken, they challenge it. They challenge it before this court. Until such time, my courts may allow us to actually continue. The moment we are found guilty, they have every right to do that.
How can it be with a criminal case pending as a prosecutor? Can you prosecute others?
Lordships on 14th October 22 were of state misconnection. This SLP needs to be allowed.
Law mandates that each accused is entitled to be presumed innocent until found guilty.
8 and 9 at page 5.
In this matter alone?
In this matter alone.
21 point.
And all others are dismissed.
How can you, Mr. Newley, you want to prosecute people?
Well, but we have not been found guilty. I can still understand, okay, there is a conviction against me. None of those proceedings have culminated. It is almost a pre-conviction, Your Lordship.
Yes, thank you.
Great.
Deeply obliged, my lords. Obliged.
Number my lord, 30 and 30.1 my lord. My lord, before the High Court, my lord, the matter is listed on 5th November. Other side is it. I have no objection, but before 5th November, my lord, because the
High Court is not?
There are two kinds of orders passed by. We have an order passed by 9th of August.
that is on different footing, my lord. My case is on different footing, my lord. My case has been final up to this Sunday.
Why we'll put it on some Tuesday? Why? What is the difficulty?
Saying that before 5th November, my lord, any date, my lord. Because
Before 5th November?
Sir, 5th December, I am sorry, my lord. 5th December, my lord. I am very sad. Before 5th December.
Now, irrigation is also long.
Yes, Mr. Kaul. Put it on some Monday week.
Yes, my lord. No, it's item 30. Sorry, I wasn't unmuted. It's item 30, my lord. There is some urgency in this matter for the state of Gujarat. Despite your lordship's order, my lords, the review proceedings are not going on. In another writ which had come before your lordships had specifically said that whatever orders have been passed cannot be construed to mean that the review proceedings cannot be heard. But that was a separate writ petition where an order passed in this SLP was shown. So we had gone ahead and to say that the review should be heard. It's not being heard in the exchequer, and the stakes are so high for the state of Gujarat because despite clear judgments in our favor, in the case of Ad hoc Teachers Association, the same principle is being applied to contractual teachers, which has been held to be non-applicable at all, my lords.
Okay, we'll have it Monday week.
Let's item very grateful, my lords. Very grateful.
Please.
Item 35 not it relates to NEET PG 2024.
Tomorrow it will go on next Tuesday now.
Well, it's item 22 minutes. Item 22 minutes.
Yes.
The very next item. My lords, may can have next Tuesday at the top of the board. We've been suffering in interim orders last 1.5 years.
Next Tuesday.
But 25 may also come. 25 may also come next Tuesday.
letter of 7, third of the 7. Till date, there is no High Court orders which are in favor of, contrary to what the Supreme Court is. Patna not challenged, Kerala not challenged, Tripura not challenged. Those orders continue to be in force. Yes, all of them are now.
How about Punjab?
Punjab is pending. There is subject. Odisha is also subject. In Odisha, Bihar is not challenged.
No, the judgments, final ones are Punjab, Assam, Tripura, Kerala and Patna.
Yes.
All the others are still pending in the High Court. But it will be decided on the basis of this.
No, but yes.
There's already decided because of
There's one more part to this.
He's obviously given a foundation to Patna and Tripura wrong. So which High Court will be bold enough to take a decision?
There's one more thing that we had done, which we have stated in one of the MAs already. There were 2 writ petitions pending in Patna and Delhi, to which we filed a transfer petition in Supreme Court, saying that this judgment will not really apply to us because this helped with only, this gave benefit, or this reserved thing only for insolvency. So therefore, since the question of law is same, please transfer these things to Supreme Court. Justice Oak had it, and he issued notice granted stay. That will also ultimately follow this.
They have to come out.
If it happens. As of now, it is with Justice Oak, then it got transferred to this court.
It is too late.
We have put proof that all of them were in service. Somewhere down the line, there seems to be confusion. There seems to be a confusion in their mind that it was only for in service, but all of us are in service. There is no question of not being in service. That we have to prove so.
That's a precondition.
That's the precondition for any person taken in IA on service.
What do you say?
Please, Just say that there are 9 MBAs. I've been in the enlistments for 100 candidates who have not been participated in the ship.
So your lordships are well aware of what transpired. Now it's this review petition. While they're not all parties, it covers and will have an impact on about 12 lakh teachers who were in service at the time that the RTE Act section was amended.
So that is what we have held that that special 18 months course was for protecting the teachers who are already in service.
Correct. So
But it can't be made applicable for future employments. That's what we.
Yes. So if I may, the idea, Manoj, was simply this: that in curriculum and in everything else, the program is exactly the same, including the internship period. It's a 24-month program.
No, it's a 18 month.
No, the program that has to be followed as has been laid down by NCTE is a 24-month program. Now, the relaxation that was provided to ensure that they fall within the timeline because section 27 was amended and the proviso was included, which allowed those in service to complete by 31st March 2019, which required it to be completed in less than 24 months. So that's why the relaxation was brought in so that they will finish in 18 months. Now, what has happened is, Malons, that 18-month period is being treated as equivalent not by the Uttarakhand High Court. Your Lordship judgment says that the High Court couldn't have gone in and created an equivalence. That perhaps is not what I think would be borne out from the record, because there were actually an expert committee that had been set up by NCTE. All this took place on directions which were directed by the central government by exercising its powers under Section 29. There were advertisements which were issued with the Prime Minister's photo on it, saying that please ensure that you will complete this by 31st March 19. The idea was that once, as an in-service teacher, I get that qualification of 18 months. It is exactly the same as anybody else getting a 24-month qualification. Now, the effect, my lords, of your lordship's judgment is that in schools, for example, which have gone through the plight of COVID, who have had to close down, etc., those teachers, when they step out and they apply, they are told that, sorry, this is not being treated as equivalent to the 24-month. That is the problem. It is, in fact, I just wanted to show your lordship of 3-4 documents which will show what the background is. What took place is, and all this took place over a short period in the middle of 2016. The first thing that took place is that the MHRD issued a letter to all the secretaries. MHRD said, look, we have found that there are in-service teachers and we must take care of them. So MHRD tells the secretaries that NIOS will be the institute, and through that we will have this course. The idea throughout, and there has been no different stand that has been taken either by MHRD or by NIOS or by NCTE or by any of the universities or any of the state governments, that the 18-month program was to ensure that those in-service teachers will get the same qualification that those otherwise would have the benefit of getting over 24 months. The others could take 24 months over it languidly because they were not in service. Those in service, if they have to take a full day 24-month course, they can't also be teaching at the same time. That's the practical difficulty. So what the MHRD did is, this was on 3rd August 2017. Barely 6 days later, my lords, the amendment that they suggested gets the approval of the president. That amendment that is made to the section. Which is why on 21st August 17, all this is taking place in the same month, in August 2017. On 21st, sorry, I'll just take your list. I'll just give you the dates with the pages in just 2 minutes. 21st August 2017, in the same month, MHRD writes to NCTE under section 29 of the NCT Act, directing the following relaxations. If for a minute I can just read out section 29 of the Act, because that is relevant. That's where all of this starts for us. NCT. नहीं, NCT, National, वो शायद इसके अंदर होगा, check it. NCT. No, NCT, the National Council for Education. I'll just hand this up. I'm sorry, one copy, that's mine. Section 29, if your lordship sees. It gives the central government the power of relaxation. So this is taken at the highest level. It's not that the High Court in the impugned judgment decided the equivalence. The relaxations that were directed in exercise of this power by
the council shall, in the discharge of its functions and duties,
yes,
under this act, be bound by such directions on questions of policy as the central government may give in writing to it from time to time.
Correct.
The decision of the central government as to whether a question is one of policy or not shall be final.
Fine, correct. So on policy decisions, therefore, section 29 is the central government's power to give those directions, and the NCTE doesn't have the option of saying, no, this is not binding on me. NCTE has to follow suit. Now this takes place on 21st August 2017. Now we have a convenience compilation given your lordship, which shows what they've done under the section 29, the same month, which is at page 53, Manoj, of the convenience compilation. Second convenience compilation. Page 53. Second one.
Yes.
This is your lordship, page 53. This is regarding training of untrained in-service elementary teachers in or in these schools, an amendment to section 23(2) to extend the period for such training to 31st March 19 has been passed by Parliament. Your Lordship will see this
Where are you reading? Page 53?
Page 53, the first para. This is 21st August 17 letter, Manoj. Your Lordship. Yes.
This is regarding training.
Yes, regarding training of untrained in-service elementary teachers in government schools, etc. An amendment to section 23(2) to extend the period for such training to 31st March has been passed by Parliament. Please note the date, this is 21st August 17. So therefore 2 years are not available now. It's only till 31st March 19. In this regard, it has been decided that NIOS will be the singular organization responsible for conducting the online DLED program through the SWAYAM portal, etc. The tentative number of in-service untrained teachers at elementary level is 11 lakh. That include teachers working in government, government-aided and private unaided schools. However, the actual number may change. NIOS will be completing all academic activities related to above training by 31st March 2019. This is for the same DLED to get that qualification. To ensure the above training through NIOS, NCTE is directed to provide following relaxations under 29 of the NCTE Act, which your Lordship just saw. So this is the government's direction. Teachers who do not fulfill the minimum eligibility requirement for taking admission in DLED program, 50% class 12, will have to join NIOS and reappear for class 12 exam to achieve minimum qualification. NCTE shall allow such teachers to take provisional admission in DLED program of NIOS, subject to them acquiring 50% marks in class 12 before completing the DLED program of NIOS. This would facilitate such teachers to pursue both courses concurrently. This is important, Manoj, concurrently. The DLED course will be from 3rd October 17 to 31st March 19. This is the DLED course. The duration of the course will be for 18 months. As the DLED program is of 2-year duration, NCTE shall allow subsuming of 6 months internship period within the duration of the proposed online course through the SWAYAM portal, as all the teachers are in service and are already teaching.
So therefore, all the teachers are in service.
Exactly.
And are already teaching.
Correct. And
so therefore, we said that such of the teachers who are in service will be protected.
Correct. Now will be protected, but the online DLED course that they have done, which is an 18-month course, will permit them to have the full DLED qualification as is required under the Act. So the minute I finish this online course, my lord, which includes the 6-month internship period in it, therefore 18 plus 6 is effectively 24 months, effectively that, I have the full DLED qualification as is required by the NCTE for the purposes of the RTE itself. So for the purpose of 23, I have to have the qualifications with the NCTE will lay down. NCTE says for DLED you need to have a DLED 2-year course. That's what NCTE says. Now the ministry gives a direction saying your 24-month course cannot inure to the benefit of teachers who are in service who don't have 24 months available to them by 31st March 2019, which is why this sentence is important, if I may read that. As the DLED program is of 2-year duration, NCTE shall allow subsuming of 6 months internship. So while I do the 18 months, I will also be in 6 months of that, also doing the internship alongside because I'm in service. I hope I'm making myself clear. I don't want to repeat myself unnecessarily. The idea is that 18...
No, the question that is whether this qualification has been made as a special provision only for those teachers who are already in service, or would also be a qualification for future.
It cannot be a qualification for anybody who is not in service. It cannot.
So that is what we have held.
No. So if I
the Uttarakhand High Court had held that this 18 years diploma is equivalent to 24 months, and therefore they could apply for the assistant teachers post available in the state of Uttarakhand.
But your lordships have reversed that part of equivalence, saying that the court could not have deemed equivalence. These two courses are not equivalent, is your lordship's finding.
So therefore,
the effect of that is...
are you a person who is already in service?
Yes, we are all in service.
But they are already protected.
So I'll explain what the problem is. Let me clarify. If I'm in service and if I'm in that one school for the rest of my life, your lordship's judgment protects me. But if I want to go to another school and that school asks me, where is your DLED? I show this. That school now, using your lordship's judgment, will say, No, you don't have the 24-month DLED qualification which is required because the Supreme Court has reversed the Uttarakhand High Court's finding of equivalence. Because the Lordship reversed the finding of equivalence, my 18-month DLED course is treated as some special requirement for me to remain
In service, yes.
only in this school. But I can't move from one school to another because it's not being treated as a DLED 2-year qualification, which is what is required on the NCT. Now, apart from the impugned judgment, there are 5 other high courts which have given the exact same judgment of equivalence. 2 of those your lordships considered, which is Patna.
But Bihar and Uttarakhand.
Yeah, you dealt with Uttarakhand, but at para 32 of your lordship's judgment, you have said Patna and Tripura were therefore wrong. So the effect today, my lords, and there are other petitions.
I think Tripura was Justice Qureshi's judgment.
Yes, it was Justice Qureshi's judgment. Now, the problem is twofold. One is of movement. If I, as a teacher, want to move to any other school, I now have a hurdle where I'm being told, look, your 18-month DLED is not to be treated as 2-year DLED. Why? Because the NCT regulations have, the overarching regulations, those regulations say your qualification under Appendix 9 and 11 of those regulations are that you need a 2-year DLED. That's what you need. So this is not technically a 2-year DLED. So the schools which say no to me may not technically be wrong. They may not be wrong in saying, look, the requirement is 2-year DLED. You don't have 2-year DLED. Supreme Court has said 18-month DLED is not the same as 2-year DLED. That's my hurdle. That's hurdle number 1. Second is, if I belong to the unfortunate few the schools have closed for one reason or other, it could be COVID, it could be any one of other reasons, then I'm left with nowhere to go. Otherwise, your lordships would protect me to that limited extent. And the third thing is most important. There were 2 SLPs which came before your lordships. One was by the state. I don't know how they are aggrieved exactly. And the second.
No, they are aggrieved. We recollect Mr. Sethi vehemently argued on behalf of the state of Uttarakhand.
So he relied heavily on the state's rules. Now the state's rules had in fact subsequently been amended. And the state's rules said, as an alternative, anything that may be prescribed by
The question before the Uttarakhand High Court was that whether such persons who were having 18 months diploma could be permitted to compete for the post of assistant teachers which are advertised.
Who are in service?
No.
It's only in service, Mullah.
In service.
All of us were in service.
In service. How about that?
So no, he's not just talking about the High Court. The High Court.
As teachers
Yes.
who are already in service on the date of
Yes.
this notification is concerned,
Yes.
there can be no dispute that for them it will be qualification requisite qualification equivalent to 2 years diploma.
That's it.
But not for the persons who are not in service on this book.
That's that one sentence that your lordship is the only thing that I want. That's
So
all.
that is what we have held with. The judgment is being misinterpreted.
That's the problem. The admission is interpreted, so if that can be clarified, that will be enough.
What he wants that this qualification should be held good as 2-year diploma course for all time to come for him. That is what he wants.
For the admission, that's a basic requirement.
The school बंद हो गया है. तो for A reason, B reason, closure है, no student. Then, though he was in service on the date of that notification.
That's it. That's only it.
So then
That's the only.
get the recruitment. This batch of person.
In any other recruitment provided on the date of that notification, he was already in service.
Yes.
Yes. That's it.
He was already,
His service, if he attempts to switch over to some other
for
service,
betterment service. Then
he will claim benefit saying that I am in service. Even today I am in service.
no, I mean, on the date of notification.
On the date of notification.
On the
Date of any other notification.
no.
It's only this one notification.
On 22nd November, 22nd September. No, where is the 22nd September?
The second volume we handed out.
Page 76.
No, but we were dealing with only one notification.
One notification. So on that note,
See, where is the problem? If you have any problem in future vacancy, or future recruitment, then you come, you are just thinking of a hypothetical situation that in future it may not inure to your benefit, therefore it should be reviewed.
As a consequence of your lordship's judgment, there is a series of notifications. One of them is by Assam.
Page?
Page 687, there was another compilation one, not this one, the other one, Mota Wala.
इसमें page 76 में तो there's some.
That's the first sentence. Now that is.
No. Where is that order dated 22nd of September 2017?
Page 63. Same one. Page 63. Difference order. This page 63.
ये कौन सा कंपाइलेशन बता रहा हूँ?
Put on, wait. It is there.
The two separate documents for your
Page-
I'm sure.
Page
63.
63.
63 is what my Lord Justice Gawai asking about, which is the 22nd September 17 recognition order. The third paragraph of that, if you can see for a minute, at 63,